My Lordship. Lordship, I'm paying for listing for withdrawal money. Fine.
May I please, Lordship?
All listing matters you can give it.
I beg to mention withdrawal, Lordship, item number 52, Lordship. Petitioner got the relief, Lordship.
Contempt.
52, WP, Lordship.
You are Ms. J.
J. Chetri, Lordship.
Ms. J. Chetri, learned counsel for the petitioner. On instruction submits that the violation, the directions passed by this court wide order dated so and so in WPC number dash so and so has since been complied by the respondents. Accordingly, she submits that the present petition be closed as having become infructuous. Good day. The prayer is not objected to by the learned counsel for the respondents. Accordingly, the present petition is closed as having been. It will not violation now. The reliefs claim for in the present petition.
So I recommend item 27 with the consent number authorized. Can it be on next week, Lordship? 27. Yes,
Why?
On next any date, Lordship.
Why?
So I misplaced the file, Lordship. So Lordship. Lordship. Next
Mr.
any
N.J.
date.
Goswami, N.J. Gugoi, learned counsel for the petitioner, submits that the file, that the brief has been misplaced and accordingly prays that the matter be taken up on
Any date, Lordship.
27. 27/4/2026. Prayer accepted. Registry to list this matter again on 27/4/2026.
Lordship.
Oblige this.
With other party consent, kindly pass over the item number 36 for the day. Just after 2 weeks.
You are making this prayer on behalf of?
80 Sarkar.
Prayer is made on behalf of Mr. A.T. Sarkar, learned counsel for the petitioner. Adjournment in the matter on account of personal inconvenience. Prayer accepted. Registry after 2 weeks on a date.
Oblige, Lordship.
Mr. Goswami, what are you waiting for?
Item
Item?
5, 6, 7.
5, 6, and 7. Respondents are here.
Is relying on a judgment of a
Noor Islam.
apex court. Yes. But he has given me a copy today morning. But I'd like to go on.
Is a copy which is in circulation for a long time, Mr.
But
Kaushik.
I'll like to examine this. But
Mr. Goswami, how do you intend to apply Noor Islam in your case? You are not a music teacher.
yes.
But the process is, your lordship know it.
No, I know nothing. You must
No,
tell me. I want to know from you.
Look, the schools, venture schools are there all over. So 2011, the act was passed. They wanted to provincialize these venture schools. So a process was provided for under that act. There are two. One is the institutional eligibility, and once that is satisfied, then the teaching staff and non-teaching staff, they have their provisions as to how they will be selected and how they will be processed. So in the instant case, Milord, the provincialization took place. The institution is fulfilling all the requirements. Therefore, you go to the teachers and non-teachers of the school. That also has gone through. And the initial committee, district level committee forwarded the names. Then, section 10 came, that was scrutinized. So that was sent. Then the notifications are annexed to that the names of the teachers who have been found eligible, their names are there.
So you mean to say that 10-4 was satisfied and the government notification is available on record?
That is the last stage, the notification from government.
No, that is the end stage of 10-4. Then it comes to section 4, wherein the ministerial, I just use that word, the ministerial order is issued because under section 6,
correct.
Once a notification under 10-4 comes, You are already a government servant.
My lord,
But I don't find that 10-4 notification, completion notification in your cases.
my lord,
Is
the-
it on record?
The whole problem is, my lord, at that stage, the judgment of the High Court came, invalidating the act.
So 10-4, until and unless that process of 10-4 is complete,
My lord, no,
can you hold that
No,
you have been
no.
you have become a government servant?
no, government servant will be, my lord, those who have been found, and then a notification is contemplated.
Not a notification exactly. Sir. That's
10-4.
my confusion. Because now the thing has gone a change. How we have to look into it.
District level committee.
The order of provincialization.
No. What I am on is whether after the matter was sent to the government for creation of posts and all those things, a notification as contemplated under
Under
10-4
10-4.
was issued.
Yes. And thereafter, what your lordship said is a ministerial part is the provincialization order
Order.
that for the section 6.
Because section 4.
Section 4.
Because by virtue of section 6,
6.
once a 10-4 notification is issued, they become government.
They are deemed to be.
If you're holding the same book,
Yes,
Mr. Goswami, if you can come to subsection 4 of section 10, that is at page 658.
653 it starts, my lord.
Starts at 653. But the relevant provision is 10-4.
Yes, Lord, may I just start from 4? At page 653. The services of the employees of all eligible venture educational institutions under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from that date, provided such institutions have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as on the date of coming into force of the act. Therefore, my lord, once that happens, they are deemed to be
But you will have to read that in the context of
the
10-4.
services of the employees of all eligible venture educational under section 3 shall
Then,
be deemed to have been
Goswami,
provincialized.
then Mr. Goswami,
Yes.
in spite the fact that the act is not longer in force,
Correct.
all schools, because it's not that the other schools which have been not provincialized under 2011 were not held to be eligible. So, in spite of the setting aside of the act, this court has to hold that whatever be it, all schools which were brought under the purview of the 2011 Act, District Scrutiny Committee had considered, then all those schools' employees therein will be deemed to be provincialized, even if the Act of 2011 is not existing in this.
Correct,
period.
Willard. That is why I am saying, kindly have a look at the notifications we have annexed.
No, if you can just come to 10-4.
Yes. 4.
Yes,
Yes. I was just placing 4 only.
10-4, 10-4. District Scrutiny Committee shall forward the verified list of eligible teachers school-wise in accordance with the number of posts specified in the schedule to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for getting their services provincialized.
Correct.
So that list has to be published by the
Correct.
state
That's what
government.
I just wanted to show that.
Then you just come to
Yes.
6.
Yes.
With effect from the date of publication of the notification under subsection 4 of section 10, the
Your lordship
superintendent's
is
control
reading?
and all educational institutions
6.
coming within the purview shall vest in the state government. So 4 is just a ministerial act. Where is the notification in the first case?
No, my lord has read which one, my lord?
6.
Section 6. 656.
Just a page ahead.
Yes. With effect from the date of a publication of the notification under section Subsection 4 of section 10, the superintendence and control of all educational institutions coming within the purview of this act shall vest in the state government.
So they become, once that 10-4 notification is issued,
Correct.
automatically they become government servants. That means their services have to be deemed
Correct.
to be provincialized.
Yes.
Now, where is the notification published of the employees under 10-4?
Milord, if you will also see the item number 6.
Yes, Somerset does.
Page 35 is the concerned entry. Page 35, Milord. Dekiajuli, name of the LSE and name of the institution is postal letter, Goromara High School. This is the school we are concerned with. And then Milord, date of recognition, date of,
Your names are included here.
yes, Milord, under column 10. Someshwar Das is petitioner number 1. Rajat Boro is petitioner number 3. Narendra Limbo, petitioner number 4.
Okay.
Subut
They are there.
Talukdar, petitioner number 2. Bijoy Thapa, petitioner number 6. Indra Kumari Limbo, petitioner 7. Binoy Kumar is petitioner 5. And then Otul Sarkar is petitioner number 8. And Vinanda Basumatari is 9. And if your lordship sees the top, name of the employees of 2-class Venture High School, High Madrasa found eligible for provincialization under section 4(1) of the Act. And your lordship at the same time, page 40. Same thing is repeated below at page 40. Same name, same notification. Then Milord, the eligible institution list is at page 42.
These lists were published when? The date of publication of those lists.
They were earlier to the judgment, Milord.
But there is no date here.
Date is, I have also noted. I think it is.
Under 4(1), so it has to be before that.
It is a notification under 4(1), Milord. So it is date to night one when it is petitioner. No, no. This is how they do it, Milord.
So there is no counter filed by the state
No,
denying this.
no, these are all accepted facts, Milord. Page 42. 2. Kindly turn to page 42, Milord. In pursuance of government notification dated 30th June 24, the earlier non-recommended school which completed 10 years of imparting education with recognition, etc.
Yes,
on-
Mr.
were-
Malad, this is a list.
Is published. If that
No,
is
no,
the
that's-
list under section.
No, that is not
10(4)(a),
the- Malad,
where
that-
is your material to?
No,
them?
Malad,
From
we have not-
19, these matters are pending before this court. If
Right.
you are not interested, that means we'll have to go by the pleading, what is there on record.
I'll file my reply, my lord. Your lordship will kindly come to page 658 of the book, my lord. The district will first forward the list to the director, my lord.
See,
Then the
this is-
director, my lord,
This has a heading here that name of employees of so and so madrasa found eligible for provincialization under section 4(1) of the Act.
Yes.
So 10(4), if this is the notification.
That is
issue,
not the.
Where do
Well,
I get it?
let me just come to the section 10(4) Malu once.
For that, Milord, may I just turn to page 43 for a minute? District-wise summary statement of eligible institution along with total number of eligible staff. This is the thing, Milord, at page 43. Kindly turn to page 45. Serial number 80, Goromora High School. 16 number. So this is the total list. And they have found these names, which your lordship has seen already. And we are the petitioners. And then they also forward 9th January.
Okay, the
25.
initial
Kindly
scrutiny-
turn to your lordship asked for a date, page 46. The school 9th January 2015. This is the from
Creation of the post.
Deputy Secretary to the Director asking for the financial projection with regard to the years in question mentioned therein. So this whole process started, Milord, in 2015. And then, Milord,
Because of the interference of the rules, this was
yes, and then 46A also, creation of posts for provincialization of services of 80 number of newly provincialized.
no.
schools.
Now, if we apply the division bench's judgment
Yes,
and the judgment of Noor Islam, the
Yes.
principle there.
yes, I was thinking of that
So
only.
it comes to a logical conclusion that if the posts have been created, if the government has given its concurrence, then the process under 11 has taken place. So go ahead.
Well,
Yes, what do you want to show?
Well, the list which has been shown, my lord, that is the list which was forwarded by the director under 10(4) to the government.
Where
is-
is that? That is what I want. Where is that? Where is that material?
This is the list.
There is nothing there.
No,
The pleadings are that this is the list on conclusion of 10(4). You have not counted that.
And 47.
lordship will give me
there is
10
a
days time, my
letter,
lord, I'll file my report.
Page,
Huh.
there is a letter from the Deputy Secretary to the Director, creation of posts for provincialization of service under of 89 number of newly provincialized schools. And then.
47, that is very clear that it was already, posts were already created.
7th May 1915.
Say, Mr.
And the total number is
This
indicated at
matter
page
is pending
48.
here from 2019. And you have been afforded a number of opportunities to get your statement on record. It's a question of fact, basically.
Right.
If you can demonstrate that the list which the petitioners are relying upon,
Is not a
Is not a
notification
list.
under 10(4).
after the process under 10(4) is complete, but is a list
Prior to the
forwarding
10(4).
the matter to the government, it would be a different
Yes.
ballgame altogether.
Hmm.
But until and unless that material not being here, why should we, after 2019, the matter was instituted, today, wait for that material?
Well, in fact, the last 2
You
days,
suffer
Well-
for your inaction, you suffer.
my lord, lordship will give me last chance, my lord. A week time, my lord, I'll bring on record, my lord. My lord, because the process, my lord, my lord, under the 2011.
Mohar Ali Sheikh is binding on me.
You're right.
And the interpretation of Mohar Ali Sheikh given by the Supreme Court, because Noor Islam, there is an additional factor to the effect that matter went, and then the creation of 214 posts.
In
was
respect of
pending.
music teacher.
Music teachers were pending, and the petitioners had contended that they were there. So if that be the projection, that means in that case, 10(4) was
Then perhaps, my lord, the facts would be similar. But, my lord, here,
was complete. So if here, this is if this projection that 10(4) was complete, because if you go by the subsequent documents, it seems that first phase, second phase, 2 phases, the whole process was to be done. Posts were created. Now, if you have created the post under section 6, a right has already vested.
exactly.
So you issue a notification under 4 or not, act gone or not, they are deemed to be provincialized employees from that. Only a small fact from your end, what is the that list
Yes,
all about.
I
So
got
that's
it.
your list. And from 2019 onwards, you have not been able to do
And all this has happened in 2015.
15,
And
16.
kindly see, my lord, there is a
So in fact, my
division-
lord, the list which has been
Today, if I pass this order, I'll be within my jurisdiction to pass it because I'll be quoting Mohar Ali Sheikh
and Noor Islam.
And tomorrow it turns out that this is there, another proceeding before this court in a form of a review or an appeal. And these poor petitioners, they will be put to suffering. Because they are waiting, they are nowhere now.
So therefore, my lord, I'm praying
People are
this lordship will give me a
people are
chance.
retiring.
They are nowhere.
In between, my lord, there is that judgment of the division bench.
Mohar Ali Sheikh.
Mohar
It is from
Ali.
Mohar Ali Sheikh that
Correct.
Noor Islam.
Yes, correct. Your lordship is right.
In Noor
140
Islam, I was the counsel who had appeared for term here earlier.
I see. Your lordship is very familiar. And this division bench judgment also, my lord, virtually accepted.
The only thing in the Supreme Court,
The
found a
mandamus
reason
was
that
not issued.
after having drawn this conclusion, why a mandamus was not issued.
That,
So a mandamus came to be
that
issued.
came in the Supreme Court judgment.
So the Supreme Court decision does not wash away the procedure under 10-4.
No.
It
No, no,
recognizes
it's not.
10-4.
It's recognized as 10-4.
10-4. So it's not a case that the 10-4 has been given a go by.
Go by, it's not that.
It's not that.
No, it's not that.
No.
It's within the statute itself.
It is because the division bench has hold that they have
Mandamus.
accrued a right, and there was, though there was no
143,
mandamus prayed.
143, 142 or something.
Yes. And that was also in context of section
Okay.
24 of the
Mr.
covenant.
Goswami,
Yes, Vinod.
we will give them a last chance to just clarify on that matter so that if that is the 10-4 list, we can pass a mandamus straight away. So these petitioners get their relief. We'll give them an opportunity to show, because if that is not a list under 10-4, then your right cannot be held to be crystallized. Because page 47 and page 35 list have to be interconnected.
No, the lists which I have.
We
shown,
get it, we get it.
It says that they have scrutinized, they have
Under
found them
4-1,
eligible.
4-1.
Eligible. If I am found eligible, then my lord.
Because
under-
Mr. Goswami, the practical problem
Yes,
which I have seen is
yes,
that the list, there are two stages when these lists are get published.
yes,
One is by the director.
yes,
Maybe because that's not contemplated under the rule,
no,
under the act.
Maybe
Because of the pressure created by the people going to the office, asking what happened, what happened. So what they do, they publish a list. But that list is not the list under 10-4. The list under 10-4 has to come from the government after the posts have been sanctioned.
So my lord,
So we'll just we'll make a query to that effect and let them file their, if they don't file, we'll proceed with the pleading
my
support.
lord, may I only?
Yes.
Kindly have a look at this judgment of division bench.
The
Well-
division bench of judgment. Para?
Para 144, my lord.
143, 144, yes.
My lord has got it.
Yes.
It would be relevant to mention herein that section 24 of the 2017, which is the repealing provision of the Act of 2011, doesn't lay down that the rights and privileges that had accrued upon the venture educational institutions under the Act of 2011 would stand extinguished with retrospective effect. Rather, section 24 protects all actions taken for provincialization of service of teachers prior to 23/9/16. Such action, in our considered opinion, would also mean and include actions taken by the departmental authorities in processing the applications submitted by the respective venture institutions prior to 1/1/26, seeking permission, affiliation permission, concurrence, as well as the decisions and recommendations of the district scrutiny committees. If any, recommending provincialization of the service of the teaching and non-teaching staff of the different venture educational institutions. We are of the view that those employees in whose favor recommendations were made by the scrutiny committee had a vested right for their claims to be taken to its logical conclusion under the Act of 2011. As such vested rights of those employees could not have been taken away by the subsequent enactment of 17.
This is in the context of para 143.
Yes.
Yes.
For the reason we find that so-and-so as well as the amended provision to the extent that it's same 6.2 retrospectively take away the eligibility of those ventures to seek provincialization are highly discriminatory and offense, para Article 14. By necessary implication, the aforesaid provisions take away the rights vested on this venture institution for being considered for provincialization with retrospective effect, although the Act of 2017 does not specifically provide for the same. Then if we read, okay, fine, we'll come to that. But let us first get to the facts. You get it. We'll not give you much time.
Well,
We'll give you a week's time.
well,
And it does not come, then we are going to go by the
I'll file it within.
by the pleadings already on the call.
They have not filed any affidavit. It's all admitted.
Mr. Goswami, that's the problem we are facing.
No,
Because
no, the problem is they are not implementing the statute. That's not a problem for your lordship. That's a problem for
we
them.
will do it.
Yes.
That is why we are here. That's
Yeah.
why you are
That's
before
why
us.
we have come to your
But the
lordship.
problem is, Mr. Goswami, what I'm finding is in bench 2 is that basically bench 2 matters, law will come at a very later stage. It's basically on facts. Basically, the maximum issues are on facts.
Correct.
So to get that fact adjudicated, we have to have the story from both sides. But unfortunately, it is not there.
We have filed this.
19.
19. And if in spite of that, it doesn't come, your lordship sees.
I have tried many ways after my becoming a judge here. I have tried. I have even gone to the extent, okay, don't file an affidavit. Give me a written receive a written instruction from your commissioner, secretary, director, place it before me. Even that is not forthcoming.
We'll kindly see what has happened in this case. You have the act, you have the respective authorities going into the matter. You have found that this institution is satisfying the conditions, and this list of teachers fulfill the requirements.
Mr. Goswami,
That
page
gives us the
35
right.
onwards, if page 35 onwards is what you project,
Yes.
you have the money in the bank in a fixed deposit. It's only to be matured.
when people are struggling.
It's only to be matured. That's all.
I wish we learned it. So.
Because see, until the Mohar Ali Sheikh came or Noor Islam came, this court had a different view of the matter. That once a statute is gone, not finalized, then you have got nothing. So we used to remand back the matter for consideration under 2017 Act. This I also had done it. Then a review was filed before me. Mohar Ali Sheikh was placed, Noor Islam was placed, and I reviewed my order. I have restored that file to a writ petition back to file, because now we'll have to give it a relook. Now it should be an examination on facts again.
Facts below and the facts are admitted so far as this case is concerned, because the notifications are by the government.
We'll just connect it up. But Mr. P.K. Goswami, learned senior counsel, assisted by Mr. D.P. All the three cases have the same.
No, Lordship, the 6 is of 10 years, other cases are of 7 years.
Okay.
They are to.
Which one is?
They are fulfilled.
Same thing.
In fact, their cases were sent to the finance department also.
No, all the three cases under 10.4, your claim is that 10.4 is complete.
Yes.
All the three cases, Mr. Goswami, you will be appearing.
Yes, these cases are, yes.
6, 7, 5, 6, 7. Assisted by Mr. B.P. Bora, learned counsel for the petitioners. Also heard Mr. B. Kaushik, learned standing counsel for Secondary Education Department, appearing for the state respondents. Mr. Goswami, learned senior, P.K. Goswami, learned senior counsel appearing for the petitioners by taking this court through the materials available on record, including the pleadings made as submitted, that the cases of the petitioners in the above noted three writ petitions, after the due scrutiny as mandated under the provisions of subsection 4 of section 10, had attained its finality, and a notification to that effect also was issued by the respondent authorities. He further submits that in cases of some of the petitioners involved in the above noted writ petitions, a rescrutiny was also carried out, and the schools of the petitioners there and the said petitioners were also found to be eligible for having their services provincialized under the provisions of section 4 of the Act of Pura Likhidiba 2011. Mr. Goswami further submits that the case of the petitioners having the respondent authorities having processed the case of the petitioners and the processing as mandated under the provisions of subsection 4 of section 10 having been completed, by application of the provisions of section 6 of the Act of 2011, the services of the petitioners have to be deemed to have been provincialized under the provisions of the Act of 2011, and the non-issuance of a notification under section 4 of the said Act of 2011, before the said Act was held to be unconstitutional by this court, would be of no consequence, and the petitioner services have to be deemed to have been provincialized.
In the light of section 24 of the 27,
Will not
17 Act.
will not come in, because 24 you bring it, they'll be in trouble again.
No, that's
We will
what I'm
not put-
saying, that
Section 24, Mr. Goswami, if you read Chandan Niyog and the submissions of the councils therein, and then if you read 24, 2011 Act was then the review petition. 2011 Act was held to be invalid.
correct.
Then the review was filed. Then they said the state submission was that we will bring in a new legislation and it can be given a retrospective effect. The 2017 Act was not given a retrospective effect, but section 24 was incorporated. Now, what the state has to do is, any school, any employee which was provincialized under the 2011 Act, if you read 24 minutely, they will have to redo
Review.
that exercise under the 2017 Act.
Right.
They have not done it. All 2011 provincialized employees are temporary. Insofar as Chandan Niyog read with the review petition is concerned, and section 24. All this have now to be redone, because review petition only gave them a temporary relief. The permanent relief would be under section 24. Nobody has agitated that matter till now before this.
No,
court.
just kindly have a look at 24.
You can have a look at 24 of the 2017 Act.
Protecting the orders prior 23/9/2020,
No,
2016. Yes, sir.
no. It is
On-
it goes a step further.
Until it is reviewed.
That's it.
Until it is reviewed.
So and so has amended so and so, which has been struck down, and all rules, orders, notification issued thereunder shall stand repealed. However, all the teachers whose services were provincialized prior to so and
22.
so shall continue, and their cases shall be reviewed as per the eligibility norms set forth for provincialization under this Act. You have not done that.
Yes,
till
yes.
now. So you will put them also, all these 2011 people who are claiming, we'll put them in that you act under 24. If they fulfill, otherwise they
Yes.
get it.
In fact, that para 143 of Mohali was that, Miller.
Ki likhi sir? I'll go by what is there, the prescription of 24. Ki likhi sir? No, last story to Huigul. Mr. B. Kaushik, Learned Standing Counsel, Secondary Education Department, submits that this court, before proceeding to give a final consideration to the present to the above noted writ petitions, would grant to him further time till. So Goswami, you are here.
Yes.
Till when? And this time, please don't miss that date. You give me a date, I'll not.
Till 6th of May.
No. We are hearing the matter in the first week of May. 4th of May, till 4th of May. Also, he submits that an affidavit in the above noted
Miller, I
cases
have
covering
not-
all the issues arising. Any
Partha-
date convenient to you, we'll put it.
Partha matters are fixed. On
Any date convenient to you,
fifth
Mr.
and seventh.
When you want it, you just tell me.
It can be 11th or
11,
or
okay.
12th.
Detail the soitaric
12th,
query.
12th.
12, soitaric query. 6.
Instead of
Covering all the
instead of
issues
5, it can be 12.
arising in the above noted writ petitions. Also, prayer accepted. The state respondents to file their affidavits in all the three all the above noted writ petitions on or before 6/5/2026. It is provided that no further time shall be granted for the purpose. Full stop. Registry to list this matter again on 12/5/2025 for admission.
Can it be on 13, but it's not inconvenient to my senior brother?
We'll have it on 14 then, Thursday.
No problem.
14/5 query. An endeavor would be made to dispose of the above noted writ petitions on the next date of listing.
Grateful, my lord.
So Goswami, I just had this instruction so that some clouds were there, I could get it a bit cleared up with you.
I'll get myself clear.
No. Some cobwebs are still there. Because some things which you take in, it's very difficult to take it out. And this is the way I try to take it out from myself.
The substance is below the persons who have been serving on an education front for all these years and for whom this act had been passed and they have been found to be eligible. There's no reason for a state not to implement that act so far they are concerned. That's absolutely the crux of the matter.
Because
It's
if
not
somebody
legal.
raises this
It is
question of
absolutely-
24 and I am there, I think I'll have to come down very heavily on the government. 24. Because 24 is the provision which they ought to have applied for each and every employee who was provincialized under 24. Because it said shall. Shall. The word used is shall. Not done it. Anyway,
Problem.
14/5, huh?
Perhaps government doesn't intend to do also, my lord, because
Then you
Many
amend
of-
that. You
many of
amend
the
24.
employees have already been then.
You amend 24 because I am only concerned with the statute as it stands, not anything else, not the wish or something. You amend it, it's your act, you amend it. Otherwise, in a given situation, it will be a chaos.
That's true.
And this court will not shrink away from that, creating that chaos. Don't worry about it.
There is no chaos, Willard. They don't want to pay the teachers. That's the simple thing. As I see.
Done with.
Lordship.
Promotions done with.
Already DPC has been held, Lordship.
Okay. But Mr.
R. Sharma.
R. Sharma, Learned Counsel for the petition. Mr. Sharma on instruction submits, Mr. Enagalika, Mr. R. Sharma, Learned Counsel for the petitioner. On instruction submits that the petitioners desire not to press the present writ petition any further. Accordingly, he prays that he be permitted to withdraw the present writ petition. Prayer is not objected to by the Learned Counsel for the respondents. Also, accordingly, the present writ petition stands dismissed on withdrawal. Mr. A.R. Tabilda, Learned Standing Counsel, Higher Education Department is present. Is present.
All
right.
Hello, Bishop. Yes, Mr. Dole.
Compulsion of the appointment, Lordship.
Yes, what has happened?
Lordship,
Where is Mr. Bora?
Yes, sir.
Bora and Kukan.
Yes, Ms. Kaur, what is your instruction? Why his appointment has not been made till now?
As his opinion is yet waited,
His
Lordship.
opinion, Lordship,
That is there for a long time now.
Yes, Lordship.
You have your up-to-date instructions. We'll take it up. After some time, you get your
Lordship.
updated instructions.
Lordship.
here.
May it please your lordship. 11, 12 almost similar matters. I am not so much on merit, but on verity, your lordship.
Therein also no mandamus has been issued.
No mandamus.
Then we'll not do that.
But a direction that their representation may be considered and an order may be passed. And in fact, that order was passed in.
See, you have not even brought the person who would be affected on record.
No, we are not claiming that
How can it
we
be?
can be substituted.
Have you said that you have sufficient number of enrollment wherein additional posts is to be created? You have not even pleaded that.
No, we have not even claimed that.
Hindi teacher,
Now, if there is
Asking
no
if the-
scope under section 3111, then his case can be rejected outrightly by the.
I am
authority.
rejecting it. Why we send it?
By
We
the
are
authority.
not here to as a post office. I am rejecting it.
Since lordship in the similar matters, a coordinated bench, in their presence, the order was passed, your lordship.
I am not satisfied. And
After-
it's not binding on me.
No,
Because
binding. Yes.
there is no law laid down. So I'll not follow that. We are not going to create unnecessary problem for a person who is not before us.
No, even this court's order is not that somebody should be replaced. It is, the court's order is that a reconsideration under
See,
section
that
3111.
would mean may end up with another person who is there. And you have not even said that you are senior to the person who have been provincialized.
It's-
So your contention that is there, what we derive is that a person has already been regularized as a language teacher.
Already.
You have not challenged that. I think we'll give it a closure.
Our case is that, your lordship, since under section 3111, your lordship, there is no bar that only one language teacher has to be
Okay,
appointed.
argue.
No, I am not arguing.
Argue.
But
We'll settle that issue then. Show me the scope.
lordship. Section 3111, your lordship.
Read the whole thing along with the proviso.
In case of venture upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics, social studies, and languages. Provided that for
So now what we understand, that minimum, whatever be the student enrollment, whatever be that, subject to satisfaction of the other criterias, minimum 3 teachers in upper primary school is required. Out of that, 1 science, 1 mathematics, 1 science, mathematics, social studies, and a language. This
Not-
much only.
not languages.
Languages. Because languages, the word used is because it can be either Assamese, Hindi, Arabic, whatever it is. Now you read the proviso.
Provided that for additional posts, it shall be considered in accordance with the norms and standard stipulated in the schedule under section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2000.
So this 3 and any addition required. So the minimum is 3.
Three.
Maximum has not been prescribed. How do you go to that maximum? You refer to this is by a legislation by incorporation. It has incorporated the
RTA.
RTE Act. Now, once the RTE Act gets incorporated, you will have to show that our enrollment is more than 150 so that you can have 5 posts. You have not said that.
No, our case is also not that, your lordship. My case is that, your lordship, when the act says, your lordship,
Hmm.
that
We'll settle it now.
the word used is languages, your lordship.
I'll
Now,
settle it.
This, the legislature in their wisdom knows that in Assam, your lordship, in Assamese medium school, your lordship,
Hmm.
apart from Assamese, Hindi is a compulsory subject, your lordship. It is not that it may be there, it may, it is.
You show me the law. You show me the provision that a Hindi teacher, Arabic teacher, irrespective of their there being students, there being not students, any language teacher being provincialized, they must be provincialized.
No, that is not what is specifically
What
stated
can
in
I
the
do?
Act, Your Lordship.
That
But
I
there is
cannot-
absolutely no
I
harm
cannot
that-
read into something into the act which is not there.
Suppose there are 2, 3 Hindi, if Hindi language teacher is not provincialized, Your Lordship, how this Hindi subject will be taught in the
That is
school?
that is the headache of the government, nothing to do with this court. I'm not here to run the management. I'm here only to implement the act as it is.
Now, if we follow this, Your Lordship, then suppose only an Assamese teacher has been provincialized. In fact, in Assamese schools, there is no Assamese language teacher.
But
He is
these
the
are
social
not,
studies teacher, Your
these
Lordship.
are not. You assail 311. 311 was assail. Nothing happened. Morally,
Therefore, what I am not-
311 was also under challenge.
It was
Nothing happened.
Nothing happened, Your Lord.
This
That's
court did
correct.
not interfere with that.
What-
So 311 upheld.
Upheld, Your Lord. And I am saying that 311 does not put any bar or there is no any embargo, Your Lordship.
Okay.
If the word language, otherwise it will be an absurdity, Your Lordship. Suppose Hindi language teacher is not provincialized, Your Lordship, whereas Hindi is a compulsory subject, Your Lordship.
I'm sorry, Mr. Prosper, that argument of yours, I cannot accept because that is not born out of 311.
And is
That
that,
may be an ideal situation you are saying,
Lordship.
but the legislature did not contemplate that. It says, if it was in case of venture upper primary school, if this language was like this, in case of venture upper primary school, there shall be at least one teacher each for so and so, I would have understood. But that is specified, that is qualified by minimum 3 teachers. So 3 teachers, 3 posts.
no, Lordship, since we have raised the issue, let them clarify as to how they are going to settle this language, Your Lordship. Hindi language is a compulsory subject. That is my case.
That is a non-issue.
Had it been not a compulsory language, compulsory subject, Your Lordship, I would not have argued this case.
You show me. You show me the right, then I'll ask you.
Page 24 in this regard, I'd like to refer to a letter which was written by the director at that time, Your Lordship.
That is a letter giving a recommendation. It was never brought into effect.
No, therefore, what the director has written after passing of this enactment, Your Lordship,
Huh.
in
He
2019,
said that this is an ideal situation that has to be there.
Lordship.
But the government did not
Take it.
give anything. The act has not been amended.
Now, Lordship, let them file a small
Fine.
affidavit. What is their stand regarding this,
Will-
Your
will
Lordship?
not-
Whether it is.
They don't file affidavits. And why should we now ask them to file an affidavit in a non-issue? They don't file affidavit on issues. In a non-issue, I'm not going to ask them to file an affidavit. And you come to page 45,
Page 45 of the writ petition, Lordship.
writ petition.
Yes, yes.
This court has interpreted the provisions of section 311 in the way I was trying to place it. So para 20 onwards, it's just nothing. Because the interpretation is at para 16, 17, 18, 19.
Yes,
Even
having-
if I dispose it of, they can't go beyond para 16, 17, 18 and 19.
Yes, having
Why
con-
should I do an unnecessary thing? The
having
court
given-
was very benevolent, fine, very good.
we seek a similar benevolence from this. Let it be considered by the authority and then they can dismiss, Your Lordship.
You withdraw it, I'll give you liberty. Nothing more.
Maybe adjourned.
No, no adjournments. I've adjourned many times. I'll
Importantly-
take it up after some time. You make
Lord-
up your mind.
Lordship.
You make a prayer
Yes.
that you want to withdraw this application to approach the respondent authorities or any forum under section 19 also, education tribunal also. I'll allow it. I'll give you liberty.
Oblige, Lordship.
But I'm not going to pass an order.
11, 12, Your Lordship, similar.
Same.
Lordship.
13, 14, 15.
Lord, 13, 14 and 15. I have very short prayer, madam. I filed petition before the authority on compassionate ground, madam.
Appointment.
Yes, compassionate appointment. My prayers, limited prayer is this. The authority may reject my petition.
Compassion.
I'm
allow-
rejecting it. Why I put it to the authorities? I'm rejecting it right away. That's the only prayer you have? Take them. M.A. Sheikh, heard Mr. M.A. Sheikh, learned counsel for the
My
petition.
lord, the petition I have filed before the authority.
That I am considering. You are before me, I'll consider. Nothing is here because that scheme has been done away with. Heard Mr. M.A. Sheikh, learned counsel for the petitioner. Also heard Mr. U. Sharma, learned standing counsel, secondary education department. Appearing for.
For respondent number
State-
one and five
For appearing for the respondents number one
and five.
and 5. Also heard Mr. K. Fukan, learned government advocate, appearing for the respondent number 2, 3. 2, 3, and 4. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities to consider his case for appointment on compassionate grounds in pursuance to the death of his father in harness occasioning on 4/4/2025 while he was serving as another appointment on compassionate grounds in pursuance to the death of his father in harness. Full stop. The petitioner, the father of the petitioner, Mohan Kuli, while working as a junior assistant in Rotanpur Miri Town High School, bracket a provincialized school, bracket over, had died in harness on 4/4/2025. The petitioner thereafter submitted an application for on 8/10/2025 with praying for consideration of his case for appointment on compassionate grounds. The said application not being considered, the petitioner has approached this court. So I've heard the learned counsel for the parties, and by way of instituting this petitioner, approach this court by way of. I've heard the learned counsel for the parties and also perused the materials available on the court. The father of the petitioner, as noticed here in above, had died in harness on 4/4/2025. On the date the father of the petitioner had died in harness, the scheme for appointment on compassionate grounds in vogue in the state, as notified by the office memorandum dated 1/6/2015, was no longer in currency. So, the respondent authorities, by notification dated 14/9/2017, had notified the scheme apostrophe for compassionate family pension in lieu of compassionate appointment. Also, the said scheme was to be applicable with effect from 1/4/2017. The said notification dated 14/9/2017 in the provisions of clause 5.11 thereof mandate that the compassionate appointment scheme would continue to be applicable in respect of those employees who died in harness on or before 1/4/2017 and after 1/4/2017, the compassionate family pension scheme would be applicable. Full stop. The father of the petitioner, admittedly having died in harness on 4/4/2025, the case of the petitioner would not be permissible to be so considered under the erstwhile provisions of the compassionate appointment scheme as prevalent compassionate appointment schemes, and the family of the petitioner would now be entitled, if so eligible, to the benefits of the compassionate family pension scheme in terms of the provisions of the notification dated 14/9/2017. Accordingly, the claim of the petitioner for consideration of his case for appointment on compassionate grounds stands rejected. The family of the petitioner, however, would be at liberty to approach the respondent authorities for consideration of their cases for being authorized compassionate family pension in terms of the provisions of the notification dated 14/9/2017. With the above observations and directions, the present writ petition stands disposed of. Same order, it did Taki to take
14.
the date of the and Nam to.
14 and 15, my lord. Some are t-shirts, my lord, that
We will do.
that may be changed. Oblige, your lordship.
And if they are entitled to CPF, give them. Give them CPF. They are entitled to that.
Let them apply. First apply, yes.
You
yes.
apply.
Oblige.
In this case, my lord, the petitioner had earlier,
Yes, who is appearing?
we are agreed by the order dated 13/2/26.
Yes, who is appearing?
I'm appearing, your lordship.
You are appearing for the respondents.
Yes, your lordship.
Heard Mr. S. Learned Counsel for the petitioner, also heard Ms. P. Das, Learned Standing Counsel, Secondary Education Department. Ms. P. Das is granted time till April 5, 2026 to complete her instructions in the matter. Also, it is given, considering the nature of the grievance raised by the petitioner, it is provided that no further adjournment shall be granted to the respondents to complete, responding counsel to complete her instructions. Also, registry to list this matter again on on 6/5/2026.
I'm appearing for,
Or 4/5/2026. 4/5/2026.
I'm appearing for 1, 2,
Oh,
4.
no, you get your instructions. I only want you to get your instructions. Mr. Count,
Yes,
we can pass the order today itself, but we'll give them an opportunity. If some hap comes out when you're searching for Kesu, let us see.
I'm deeply obsessed.
My lord, if finally can after some time.
And notice.
Heard Mr.
NZ Chaudhary.
N.Z. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. U. Sharma, Learned. Standing Counsel. Huh? Oh,
Yeah.
A.R. Tawilda, Learned. Standing Counsel, Higher Education Department. Issue notice returnable 4 weeks. Mr. A.R. Tabilda, Learned Counsel for the petitioner, accepts notice on behalf of all the respondents. As all the respondents are represented, no, full stop. The Learned Counsel for the petitioner to serve requisite extra copies of the petition to the Learned Counsel for the respondents. Full stop. Registry to list this matter immediately after, on completion of 4 weeks from today.
Hola.
Is this promotion institution wise or general? All?
Only for my lord, they're having the graduation.
No. Whether it will be in Jurat Engineering College only? All. What is your seniority position in all?
Seniority position, my lord, what happened, my lord, my seniority position as per the list, 8, my lord.
8.
8.
How many vacant posts are there?
8 and 9, my lord.
How many vacant posts
My
are?
lord, that has not been disclosed.
Mr. Tavildar, get your instructions.
Not.
At Mr. D. Borua, Learned Counsel for the petitioner. Mr. A.R. Tabilda submits that he be permitted to complete his instructions in the matter. Mr. A.R. Tabilda submits that he be granted a week's time, 10 days time to
10 days.
complete his instructions in the matter. Was a prayer accepted. Registry to list this matter again on 6/5/2026.
Oblige, your lordship.
You get that instruction, how many posts are there? And please, Mr. Tabilda,
Not.
if you write a letter, if they don't give it, we'll ask them to come.
Yes,
here.
that's fine.
These things,
Yes.
these are very small issues.
Yes, that's fine.
Just tell me whether vacancies are there and what is the rule that is applicable. Because he says that the directorate rules are applicable. I have a doubt on that.
Not it.
Just clarify that. We'll dispose of the repetition.
Not.
Yes, maternity leave, why not granted?
Let me
SSA.
let me take SSA, lordship.
Who is SSA? Why?
We'll have to obtain instruction from the department. madam.
This is not done.
My lord.
A lady not being granted maternity leave, that's against the law laid down in the matter by the Supreme Court. Ms. Chaudhary, we'll do something, but let him complete her instruction. We'll keep it in the motion stage only. Item number 19, 20, 21,
Yes.
Yes.
right?
Yes.
But Ms. Heard Ms. S.B. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. P.P. Doctor, Learned Standing Counsel, Secondary Education Department, and Mr. H. Borua, Learned Standing Counsel, SSA.
On behalf of B. Gogoi, my lord.
E. Gugoi is Advocate General, he is always there. Mr. H. Borua, Learned Counsel for the respondents, submit that day we granted time till 4/5/2026 to complete the instructions in the matter. You are also appearing, madam. You are for? Miss Sharma, what Sharma? A Sharma. A Sharma. Also, Miss A Sharma, Learned Counsel appearing for the Accountant General Assam.
Well, I am 20 and 21 minutes.
And Mr. 20?
20 and 21 minutes.
19 of A Sharma Likiba, 20 and 21 of SK Medi Likiba. The Learned Counsel for the petition respondent submit that they be granted time till 4/5/2026 to complete the instructions in the matter as to why the petitioner was not granted the maternity leave. So, prayer accepted, registry to list this matter again on 4/5/2026 for motions.
Obliged, my lord.
Kindly pass over the timing.
Computer teacher, minimum scale of pay.
Lordship. They were all,
We'll examine. We'll examine. I can't pass an interim order today.
they were
You want
appointed.
it to be in before Mr. B.
Lordship, similar matter here, page 16, para 16.
Page?
Para 16, Lordship, page 16.
Page?
Page 16,
60.
16.
One six is para 16.
Para 16, Lordship.
You had approached this court earlier.
Yes, Lordship.
Lordship, in that affidavit, it has been clearly stated that they were all appointed under
Okay,
a
let
scheme.
Mr. Bora come.
Lordship.
Lordship, we
We'll
late.
consider.
Fine.
Yes, Mr. Vachaji.
Well, this provincialization of subject teacher, my name has been recommended by DLC. Then it was placed before SLC. SLC says that to be placed before joint committee. Joint committee said an independent authority has to decide, has to recommend. Then independent authority examine my case.
Everything done.
Everything done.
Item number
23.
23,
23,
24,
24,
26.
26, huh? Heard Mr. A. Bachaji, Learned Counsel for the petitioner. Also heard Ms. D. Mushahari, Learned Standing Counsel, Secondary Education Department. Ms. Mushahari submits that she be granted time till 8/5/2026 to complete her instructions in the matter. Prayer accepted, registry to list this matter again on 8/5/2026 for motions. Then complete, why keep it pending?
Lordship.
Ms. Mushahari, please
Lordship.
have those instructions.
Lordship. Extra copies, no. Obliged.
Lordship, time being lordship.
Okay. 26 will be. 23, 24, 26. Yes, Mr. Bhuya.
My lord, my lord, the college has not yet been provincialized, my lord, and it is in the process of provincialization.
And you have not even said that in your writ petition that the college is under process of provincializing.
My lord, it is just started, my lord.
Then that we'll hold it to be a private institution. You have not said that.
No, my lord.
Oh, you have not
Lord,
said anything.
No, my lord, I cannot deny or I will not submit in that
Okay.
manner, my lord, that this is
Okay.
not a private, my lord.
Okay, fine, we got it,
My lord.
Mr.
My lord.
We got it, you
My
go
lord.
ahead.
So, my lord, as per the Abdul Ghaffur Mandal's, my lord,
Hmm.
the issues which has been decided by this honorable court that such disputes are required to be, my lord, decided by the educational tribunal.
What is the dispute? Tell me, what is your dispute?
My dispute is, my lord, that my seniority position is now going to be, my lord,
I'm sorry.
not going to be, my lord. They have even
I'm sorry.
interfered with.
I'm sorry. The seniority position of yours was suppressed in
My lord.
relation to the respondent number
Private
5.
5, my lord.
But now, after the interference by the director,
My
BTC,
my lord.
the thing has been resolved.
No, my lord, that has not been done, my lord. In fact,
Oh, fine. This is not an executing court, Mr. Counsel. This is
no,
not
my
an
lord.
executing.
No, my lord, I am not for the.
The letter
My
at page 69
My lord.
of the principal
My lord.
to the director says that no, the petitioner is senior.
My
You
lord.
know, that is the end of the matter.
No, my lord, even after they have issued
If
an.
they have not done it in your school,
My lord.
take up whatever you want, break some heads, no problem, have some criminal
No, my lord,
cases.
what they have done, they have again issued an advertisement for the same.
Now tell me,
My lord.
how can we interfere with that advertisement? And why should we interfere? When you have not projected that the advertisement is to replace you. You have not projected.
No, that projection is not there
If,
because, my lord.
if it's a private college school,
My lord.
college, if it wants 100 employees, let him go and take 100 employees. What?
But my seniority position should not be.
How can it be?
My lord.
How can it be? If it is there, go before the concerned tribunal. I'm dismissing this petition. 2 grievances,
My lord.
1 redressed, 2 is not even connected to you. You don't have the locus to challenge that because you have not pleaded that they will replace me.
My lord, may I pray for a short date?
No date. No date to Mr. Bhuya. If it was a junior counsel, I would have given a date, not to Mr. Bhuya. And I made my mind clear that day.
I recall, my lord, I recall. Then, my lord, I may be allowed to withdraw, my lord.
Mr. A.R. Bhuya, learned counsel for the petitioner, after attempting to argue the matter at some length, submits that he be permitted to withdraw the present writ petition. Prayer is not objected to by Ms. N.
Chaudhary.
Learned standing counsel, BTC, and Mr. S. Das, learned standing counsel, secondary, higher education department. You are for secondary.
Higher, my lord.
Higher is not here.
No, my lord, we have submitted, my lord,
For the department of school education.
My lord, my lord.
So, in view of the submissions of the learned counsel for the petitioner, the writ petition stands dismissed on withdrawal.
My lord, with liberty may be given if cause of action, my lord.
In the event,
My lord.
it is provided that in the event when the case or the petitioner has any grievance with regard to provincialization of her services, when her case is so considered by the concerned authorities, the petitioner would be at liberty to approach the appropriate forum for redressal of such grievances.
My lord.
Okay.
Obliged.
This is an anticipatory writ petition.
No, my lord, actually, I have been debarred attending.
And Mr. Chaudhary, we will not detain him. We'll take up Mr. Chaudhary's matter and then we will take.
Mal-
Chaudhary is too busy today. Item number
25.
20.
Along with name.
25.
Third ground of litigation, my lord.
Mr. Chaudhary,
Yes.
can you take service? Can you take service, dusty service on the private respondent?
Yes, private respondent only, I think, my lord, only college.
Rest are a government, there is no problem.
Yes.
Private respondent, because he is already joined, you serve him on the next date, we will make the interim prior returnable and we will consider it. Admittedly, you seem to be senior.
Yes.
But Mr. H.R.H. Chaudhary, learned counsel for the petitioner, assisted by senior counsel, assisted by A.M. Alamgir, learned counsel for the petitioner. Also heard Mr. D. Upamenyu,
Higher education.
learned standing counsel, higher education department, appearing for the state respondents.
1 and 2.
The petitioner, by way of instituting the present writ petition, has assailed an order dated.
Not a sale, my lord. This is case something else, my lord.
Oh, sorry, that is the other one. Okay, sorry.
Yes. It is something, everything was done, my lord. My appointment was approved even by them, but they are not
Has-
acting upon
has-
my, only
has prayed for a direction upon the respondent authorities to appoint the petitioner as assistant professor of Mandya Anchalik College, Mandya,
in the Department of
which is
Education.
content in pursuance to his selection for the said post by the concerned authorities. Full stop. In view, full stop. Mr. D. Upaman, Learned Counsel for the Learned Standing Council, Higher Education Department, prays that he be granted time till. Why have you made the private respondent?
No, only but the paper is not, because everything is closed, my,
Okay,
my grievance is only against
Okay,
the
okay.
respondent.
Prays that he be granted time till 8/5/2026 to complete his instructions on the matter and apprise this court as to why. As to why the selection of the petitioner was not taken to its logical conclusion.
In spite of the approval given by the government.
Logical conclusion, although such selection is being contended by the petitioner to have been approved by all concerned authorities.
Not all by the government, my.
By the concerned authority, huh? Also, accordingly, registry to list this matter again on 8/5/2026.
8/5.
8/5. Or you want it little bit ahead?
No, but notice issued or all
No,
instruction.
instruction. Why?
That will
Motion for motion.
oblige to all.
Highly obliged.
He is an unemployed boy, so we'll not trouble him.
For since 24 months for last 3 years. And one private person is my daughter.
There is one more case, similar nature too.
Yes, I think your lordship.
I
The
confused
other
it.
case.
Confused it.
Oblige.
You are not appearing in that, no? No other
No,
matter.
no.
I made up that you are appearing.
Oblige.
Okay.
Obliged.
But Mr. 69. Heard Mr. A.R. Bhuya, Learned Counsel for the petitioner, also heard. Who is appearing?
His education, adult,
Adult education, who will appear, Miss? Adult education?
It is a, my lord, subject of school education, my lord.
Who is appearing for Director of Non-Formal and Adult Education? Okay, inquire and tell me. Also heard Mr. Dash appearing for the. This is adult education is under the elementary or
My lord,
directorate, it will be different term.
my lord, school education are nowadays holding the,
All three are school education.
I'll
You will appear.
confirm.
Confirm. So and so, who are appearing for the Learned Standing Council, so and so appearing for the respondents. So, the petition, in the present petition has projected that he has acquired the requisite eligibility criteria for being considered for promotion to the cadre of senior assistant. It's called junior assistant, senior assistant, upper division
upper divisional assistant.
assistant
Right.
in the establishment of the district adult education officer, Nagaon.
No,
However, in spite of availability of vacancies in the cadre of upper divisional assistant, the case of the petitioner has not been considered for such promotion. Also, issue notice returnable 4 weeks. Mr. Oblique Miss, June so and so accepts notice on behalf of all the respondents. No further, accordingly, no official, no. Also, register to list this matter again immediately after completion of 4 weeks.
obliged.
The violation is page 62, 63.
But Mr.
Well, only one aspect of the principal of the college body has done their job. So director has not done. I have stated in paragraph 6. Page 62, 63 is the relevant.
Also, heard Mr. B.D. Das, Learned Senior Counsel, assisted by Ms. R. Decker, Learned Counsel for the petition. Also, the present writ petition has been instituted alleging violation of the directions passed by this court wide order date, judgment and order dated 16/10/2025 in WPC number 3825/2024. So, the petitioner in paragraph 6 of the writ petition has submitted that the governing body of Sri Kishan Sarda College, Hailakandi has already recommended the name of the petitioner for appointment to the post of assistant professor in the Department of Political Science bracket SC against the post reserved for scheduled caste community candidates. However, the respondents number 1 and 2 have not, 1, 2, and 3 have not complied with the directions of the recommended this so and have accordingly complied with the directions passed by this court. However, the respondent number 1, 2, and 3 are yet to comply with the directions so passed by the said order. So, issue notice to the respondents number 1, 2, and 3. 4 and 5 we are not issuing.
For the timing.
Notice upon 4 and 5 is not being issued for the time being. Full stop. Petition to take steps for service of notice upon respondent number 1, 2, and 3 by way of speed post within speed post full stop steps within 3 working days from today.
As per the rules, my lord, I always say, my lord, lordship will not dispense with their personal appearance. The rule says so.
I have to say so.
Because the rule says, unless your lordship is satisfied, your lordship will have to dispense with their personal appearance.
The personal appearance of the respondent number 1, 2, and 3 for the time being is not is dispensed with.
Till next date.
For the time being is dispensed with. Thank you.
But because the rule
This
says
is why
that-
seniors are for.
Keep your pleasure.
Thank you. I missed it out. I missed it out.
Rule says, my lord, because
I
I'm
got
very
it.
concerned.
Because earlier these courts used to pass that order.
Yes, because I'm very
Specifically.
concerned that recently, my lord, violation after violation, they are not following the orders of the court. This is not good for the society.
It also reflects not only on the court,
For the
but
whole,
also the councils who are representing the respondents.
yes.
Because
Then
it's the
they-
institution's name which is being spoiled.
I have not seen any order being implemented.
I'm
automatically.
sorry that that's not the experience here. Orders are being implemented, Mr.
Not, but recently, my lord, I have found.
In my court,
It's
at
not
least,
me.
I'm seeing that that is the only
Automatic.
positive aspect
Only
I have
after-
with
only
the
after
respondents
filing
here.
Only after filing on the contempt. Mostly.
Yesterday, I asked somebody that whether I'll also issue a notice for contempt so that the matter can be implemented.
Yes. This is how things are. Pablo.
Yes,
Lordship, into order page 24, Lordship.
and where you provincialized?
Yes, Lordship, that is Lordship, this is 27/3 to 1996. I have joined, Lordship.
No, when were your services provincial?
Yes, Lordship. That is
2013 Act, 2011 Act, or
no,
before
Lordship,
that?
page 19, Lordship.
19.
Yes. 25/3/1996.
That is your appointment.
Yes.
When were you provincialized?
Yes, Lordship. Date of receiving graduate scale of pay, Lordship, that is page
I want to
23.
know when you were provincialized.
Yes, Lordship, page 23. And
23 years, where is it?
yes, Lordship. Column number, Lordship. Date of receiving graduate scale of pay, Lordship. I am serial number 2. Check out.
Okay, show me your appointment order by a governmental authority. Show me an order appointing you by a governmental authority. The order at page 19 is by the school, honorary basis.
Yes.
So what right do you have?
No, Lordship.
Yes, you are appearing for?
I am from KBA Lordship.
Then what happened?
Yes, my lord, the school was initially high school. Subsequently, it was upgraded to higher secondary school. That was in the year 1996. My lord, he has not annexed the relevant document based on who is that appointment that is page 19 has been issued. In fact, lordship, his appointment is illegal and no approval at all has been granted by the director of it.
Yes, that's it. Show me.
And that
Yes.
Enough. You have made enough trouble for it. You need more. Yes.
No, Lordship.
Show me an appointment of yours made by the government.
Yes, Lordship.
I will interfere with that.
Yes, Lordship, then I may be allowed to take one
Today,
week time,
today,
Lordship.
Today,
Because,
now.
Lordship, right now I have this.
Why have you filed this case if you don't have an appointment by the government?
No, Lordship.
That's what I was asking you.
No,
That is why my
no,
confusion
Lordship,
was.
Lordship, page
Mr.
23.
Counsel,
Yes.
that is why I was repeatedly asking you
Yes.
whether you were provincialized subsequently. You have been appointed in a provincialized school.
Yes.
that was upgraded, provincialized, and subsequently upgraded to higher secondary school.
That's it. His appointment is in a provincialized school.
Yes.
Dismissed.
Lordship, kindly see one thing, Lordship. Page 23, Lordship. This is the official school authority.
Forget that. You show me your appointment.
Lordship, day after tomorrow,
Okay,
Lordship.
no, not today. You want to see? Come to page 21.
Yes.
You are Abdul Mannan.
Yes, Lordship.
Come to page 21.
Yes. Yes.
Second last paragraph.
Yes, on honorary basis.
The council, we also do
Yes.
small homework. But my confusion was
Yes.
the way you have pleaded.
Yes.
I was under the impression that you were appointed in a venture school and then it was provincialized. But the page 23 details was not giving the date of provincialization. That is why my doubt. So now I'll pass order. Your service will go. Forget headmaster, your will go now.
Let me take instruction, Lordship.
2 o'clock,
Yes.
2:15.
Yes.
I can't read this file once more.
Okay.
But you confused me. I must give you credit. I must give you credit. Very well drafted. I give you that credit. That is why till 2:15 I am deferring the discussion.
Yes. Yes. Oh,
That is the beauty of an advocate. I appreciate that. You have not suppressed, but you have camouflaged, and that is what I like it.
Otherwise, a case was, my lord, some developments were there, my lord, because verification also done. All papers have been annexed, but that or
Your
the,
husband got pension or did not get pension?
no, did not, my lord. They
Okay,
applied,
then what? Mr. Das,
lordship.
you are a counsel of this court and a very seasoned one. Why have you written this page 86 letter? When your whole case is, I don't have pension, and you are asking the director, give me the particulars of my husband. From where will the director pension give you that particular? When he is not even got pension.
No, no, no.
Come
my
to
lord.
page 86.
For declaration part.
Oh, how can he declare when he does not have any particulars of your husband with him?
That is
So,
why they have.
And how do I get over the findings of the coordinate bench? I can't. The only way out for you is to file a review, the liberty which is already granted to you. Withdraw this, that's all. Mr. H. Das, learned counsel for the petitioner, submits that he be permitted to withdraw. On instruction, submits that he be permitted to withdraw the present petition with liberty to pursue the present repetition. Also, prayer is not objected to by the learned counsel for the respondents. So accordingly, the present repetition is on withdrawal. You get that thing clear, then your road would be open for 205
But
and
that
20.
issue was not raised. Because
Can I-
earlier in the all process,
Mr. Das,
Lordship.
when this court has held that your very claim is doubtful, how can the government proceed now?
But all papers were
You were
completed
found to
only
have
bas-
been married to that person by this court when you were aged 7 years.
And my lord,
Maybe wrong, maybe wrong.
but all
that-
papers have been enclosed.
Oh, that holding the field,
Hmm.
it's an order of this court,
Yes, my lord.
not a mere piece of paper. How can I go over and sit on appeal on that? Coordinate bench's order. Either you file an appeal or you file a review, get that order
Review, my lord,
modified,
again.
then you
Because
can
first
proceed.
time I have to obtain that instruction, my lord, regarding that, my lord, declaration part. Because that must be in
Mr.
the-
Das, you have still not got it. Yes, Mr. Bora, what has happened?
Actually, my lord, personal B department has seeking, my lord, opinion, my lord. That is the community. On that basis, I have submitted. my lord.
Have you placed the file before the, there is one more case pending today.
Item 4 probably,
Four.
my lord. My friend is.
Otherwise, Lordship, apart from the petitioner, Lordship, all other petitioners have been.
No, there is one more.
Elected candidates have been.
You have
appointed.
one more company, item number 4 today. Mr. P.K. Bora, Learned Counsel for the petition, for
My lord, that,
Learned Standing Counsel.
my lord, that communication of the government, my lord. My friend names may be recorded, my lord, because this is
Mr.
addressed.
K. Fukan, Learned Counsel for the Learned Government Advocate, submits that the Department of Personnel has instructed her that the case of the petitioner has been placed before the Learned Advocate General Assam for his views. And accordingly, it is prayed that the matter be taken up again on 11/5/20. No more further time would be given.
You can say, you know, whether, what is the situation right now?
You say here, Advocate General has given his opinion. Then they get it and do it. They raised it to list this matter again on 11/5/2025, 26, on which date the respondents shall apprise this court about the processing made in the matter with regard to the claim of the petitioner for being issued with an order of appointment in pursuance to the recommendations made in his favor by the constituted committees who had considered his case for appointment on compassionate. 11/5.
Obligation.
Alamgir, right? Okay. But you. Yes, Mr. And now today, don't tell me you don't have the instruction. My
Nothing
note
other-
is very bad against you.
Lordship. Lordship, otherwise the word which has fallen from your lordship is the closure benefit. There is no such word closure benefit, your lordship, in the notification, your lordship.
No, what do you mean? No, how can you say? I'll show you.
We follow the notification of 15/2/2006, Your Lordship, for the VRS that has been issued by the Public Enterprise Department.
Come to your closure benefits means what is the benefit he is to get? That's all.
Otherwise, Your Lordship, he was a seasonal employee, Your Lordship. And our stand has been taken in our affidavit that he have been paid his wages, Your Lordship.
Okay. Mr. Monto, where did we get this term closure benefit?
Yes, my closure benefit, my lord, that was at the time of sanction,
Huh.
because it was reflected in the earlier judgment.
That's what I said. I got it somewhere.
That is, yes, that was earmarked for 855 my lord employees, and my name also included there.
Where
That
do
is
I
not
get
been
it?
denied.
Where do I get it?
My lord, your lordship will, my lord.
It's 40 की मान रख ले।
That is, my lord, your lordship will find the para 16 of the, my lord, para 15 of the judgment, my lord.
Page?
Page 48, my lord, para 14. On-
against the closure liability.
Yes, on cooperation, department should submit details report backup of the closure benefit of all, along with the details of here so and so. In that report, my name is there. So my only submission that is closure benefit cannot be, my lord, only 2,200 rupees, my lord. He has given only 1 month, my lord, salary.
2,000, huh?
2,200, my lord.
Okay, Mr. Bodle, how did you arrive at this conclusion for that he is entitled to only 2,200?
Because all of them are there working more than 12 to 16 years.
Yes. Where is this scheme? What is your basis?
Lordship, on the last occasion, I have submitted my instructions that the salient features of the VRS as per dated so and so, Your Lordship. If Your Lordship. By the way,
You had given me a copy.
so I'm giving you something.
That's
Respect of its seasonal employees, Your Lordship.
Studio. Explain this to me. See the word used there by your register. He has used the word closure benefit. What is that? That's what we wanted you.
Yes, Your Lordship.
So you say that you don't use it. Your officer has.
No, yes, Your Lordship, but otherwise,
Tell
the
me.
that is the Lordship. Otherwise, the notification doesn't say so, Your Lordship.
Be that as it may, why your officer has used that? It's a very simple thing. Closure benefit means what are the benefits available to him
Lordship.
and under what provision. That much only. Okay, you mean to say you have done it in this basis?
Lordship.
Huh?
Lordship.
Mr. Monto, how long have you been working?
More than, my lord, they're all our employees, my lord, this person.
Mr. Bodle, this is your Bible. This is your Bible. You follow
That
this only?
instruction has been followed to, given to me, Your Lordship.
Okay. A last thought to sir.
12 to 16 years, my lord.
Have you done it in the way it is marked at red marks, ticks.
Among equivalent 20 days salary for every complete personal feelings.
Mr. Monto, relax.
Equivalent of 15 days salary payable to the employees for remaining period.
So they are seasonal workers.
Seasonal workers, Lodge.
So seasonal workers, it says per crushing season they were in
22
service.
days.
22 days of wages have to be calculated till for the whole period they were working. You have given them only 1 month. How? So 2,200 into 16, 17, 18. How many years are there? Months are there. So to that month, crushing season, you will have to give them. Then, or if they have a longer period of service left, that will be taken into consideration.
Equivalent to 15 days of salary, Lodge.
So where have you done it? Your orders does not reflect that you have taken into consideration that. Now we will not let you resile. We will hold that you have submitted. This is the Bible. We will follow that. Mr. G. Bodley, Learned Counsel for the petitioner, for the respondents, in response to the queries raised by this court in the matter earlier, as placed on record. Give me that.
Lodge.
The silent features of VRS as per government order number. Yeah, for my division. So, in terms of the said process, in terms of the procedure laid down thereunder, the seasonal employees are entitled to receive an amount equivalent to 22 days salary for every completed crushing season of service. That is, bracket of salary means basic salary plus DA, bracket over, or amount equivalent to 15 days salary payable to the employee for the remaining period of service, comma, whichever is less. Also, the projection made by the Learned Counsel for the respondents is not found to have been implemented by the liquidator Assam Cooperative Sugar Mills Limited in the orders passed in respect of each of the petitioners. So the petitioners were found to have been only released an amount of rupees 2,200 as is area dues. So the said amount cannot be held to have been so arrived at by making the computation in the manner as contended by Mr. G. Bodley herein above. So May G. Bodley is granted time till 30/4/2026 to apprise this court, to complete his instructions and apprise this court as to why the formula as set out in the as to why the closure benefits of the petition, as to why the benefits due to the petition on closure of the sugar mill in question was not computed in the manner as projected by Mr. G. Bodley herein above. Registry to list this matter again on 30/4/2026 for further consideration. And Mr. Bodley, please don't have, you have taken around 5-6 days. Please don't do that again. Until and unless you have some very pressing.
No, no, no.
person.
I'll do this.
Give me a Xerox of this. Xerox here.
What did you do?
Now, Mr. Monto, if that is the position, we'll see.
As per their calculation, whatever amount my even get by 5 rupees and then happy, my lord. My lord, whatever the amount, because calculation will be correct.
Mr. Mohanto will make up. You give him 5 rupees. Lest Mr. Mohanto will. It's very simple for him.
Because as per their formula, whatever I meant.
You make up calculation that they are entitled to 1 lakh, 2 lakh, 3 lakh.
At any cost.
Pay 5 rupees
200,
each and the balance Mr. Mohanto will pay.
Deeply.
He's a custodian of many things, huh?
May I please, Your Lordship? This matter relates to appointment of
Same matter, Your Lordship. Kabul Nath, item number 10, Your Lordship, same matter. Waiting for ages. DLC recommended. Your Lordship.
SLC recommended. Then
Kindly see page 40, serial number 9. Page 40, serial number 9.
have you applied in pursuance to the recent advertisement that was given? 342 writ petition. You have not applied. Then
Earlier, I filed one writ petition which was
that was disposed of, then the DLC
Then-
considered. But DLC did not make any recommendation in your favor with regard to any post. And why have they forwarded it to the SLC? What will the SLC do?
Lordship,
Ms. Pukon, this is not that case. What is your instruction here?
Regarding that, I have not received any.
Why?
instruction.
From 1918 onwards, this case is pending. This is a matter relating to higher education,
Higher-
college.
yes, yes.
Who is that? Who is that? Who is there for college? Mr. Das, why from 19 nothing is here?
I think four.
Okay. Raised it to list this matter again on 8/5/2026, reflecting the name of Mr. S. Das, Learned Standing Counsel, Education, Higher Education Department, for the respondent.
For college, Lordship,
One.
GDECA is
Respondent number 1. 1 and 2. The director, he is not a party. He is a party, but his name is not.
Name is not.
You give him an extra copy.
My lord.
Learned counsel for the petitioner to furnish an extra copy of the petition to Mr. Das. Mr. Das shall complete his Mr. Das and Ms. K. Fukan shall complete their instructions and apprise this court as to the further steps taken with regard to the further steps taken in the matter by the respondents for placing the case of the petitioner before the state level committee in pursuance to the decision arrived at in the matter of the arrived at by the jurisdictional district level committee in its meeting held on 6/6/2017. And next time the instructions are not here, the authority who is to give you that instruction, whom you have written that letter, give me the designations. We'll have him here on that same day. 19 matters are pending, no instructions. Sad. Mr. Das, you have come in for the first time, so we are not here. But you complete your instruction.
My lord.
Because it is you who have to place, not Ms. Fukan. Ms. Fukan would come in only once you place.
Madam.
Why you have not placed? Make your submissions. Or if you have placed,
I'll get the instruction, my lord.
give him an extra copy, madam.
Last occasion, we have taken time to file our affidavit. My lord, I need some time, my lord, as a last chance, my lord.
Rejected. Why? Affidavit not filed. By instructions not received. Have you informed the authorities about the pendency of the matter? If not, then we will proceed against you. Because this matter is pending since 2021. Repeatedly, time has been.
True. The process is that after issuance of notice, we used to send a copy of the writ petition, my lord. It's the last chance, my lord. On next Monday, my lord, I'll try to bring.
Yes, what is your case?
My case is that, my lord, the petitioner, my lord, was appointed as a assistant teacher, my lord, in the year 1988, my lord.
Forget that. Why your school is not provincialized?
Yes, my lord. That what happened, my lord? The headmaster of the school, my lord, who got retired in the year 2021, my lord.
Now
So,
you
my
have
lord,
not, your case is not within the purview of the respondents. No proposal has been sent to the respondents.
my lord,
Particulars have not been submitted. So how can the respondents act in the matter?
my lord, in this case, my lord, with the best of another petitioner, my lord, the headmaster had sent, my lord, but subsequently, my lord, he had left out, my lord. Since, my lord, he was to retire, my
Show
lord.
me where it was sent. Where is your pleading to that effect?
In my lord, here, lordship will find, my lord, all the necessary documents and dice code,
Well, what will I do with the necessary documents? Am I the authority to give you?
No,
provincialization?
my lord. Even, my lord, whatever, my lord, even after retirement, my lord, the petitioner had asked to hand over the charge, my lord. The managing committee
That
also
is
they
none
asked-
of this court's business. That is your internal business.
Now, my lord, the headmaster, my lord, who has served the notice, he was duly represented, my lord. He is not handing up the charge, my lord. So, my lord, petitioner being the assistant teacher, my lord, he cannot proceed, my lord.
Have you approached the authorities?
Yes, my lord.
When?
Page 36, my lord.
36?
Yes, my lord.
No.
He had approved the local limited education officer, my lord.
I don't know what headache the block elementary education has, but where did you approach the authorities that your case is to be considered for provincialization?
No, my lord.
Then?
That is not there.
Then?
Now, my lord, until unless that he got the charge, my lord, of headmaster, my lord, he cannot proceed.
You approached the authorities
Because
that,
all the documents, what happened, my lord, in this case, my lord?
when did you submit? Show me. Where was it submitted?
Well, it was on 16/9/2021, my lord.
Where?
My lord, page 36, my lord.
Huh?
That's the page, my lord.
36 is not the,
Yes, my lord.
6921 is the block elementary education
Yes, my
asking
lord.
handover charge.
Yes, my lord.
Why should we come in? It's
My
a
lord.
private school.
Yes, my lord.
Then?
Because, my lord, the school was getting financial assistance, my lord. Then the government has some.
That is only ad hoc penalty.
Yes, at a financial, my lord. Now, my lord, these were under control of the local limited education officer, my lord. In the headmaster was not handing off the charge, my lord. Ultimately, petitioner had to approach the concerned authority, my lord, that the local limited education officer, my lord.
Where is your letter approaching the authority that he is not handing over charge?
Well, that is 36, my lord.
That is 36 is to Vinod Ali. You are not Vinod
Yes, my
Ali.
lord. That video, the two, it is that.
Mr. Hop, what is your prayer here?
Prayer for consolation as well as the handing over the charge, my lord.
Rejected.
Page 24 is your lordship, kindly see, my lord. Page 24.
The private school, if the person wants to continue, he continues. This is not even brought within the purview of the Provincialization Act. Not even a consideration has been extended.
Your lordship, kindly come to page 24, my lord. The deputy inspector school, my lord, she had also approached, my lord. The deputy inspector, my lord. Page 21, my lord. 24, my lord. Yes, petitioner's name appeared in the dice code also, my lord.
You approach the director, elementary education officer, director, elementary education.
Well, first of all, DLC district authority.
No. Approach the director and the director then will consider, and if it is found eligible, she will place it before you. You withdraw this,
yes,
we'll give you liberty. Mr. S. Hawk, Learned Counsel for the petitioner, submits that the present writ petition was instituted by the petitioner with a grievance that her case for provincialization of her services was not considered by the respondent authorities. Mr. Hawk, however, fairly submits that the headmaster of the school, who has since attained the age of superannuation, had not pursued the matter with the respondent authorities for provincialization of the services of the teachers working in the school, and accordingly, the case of the petitioner was not considered by the was not placed before the jurisdictional district level committee. So, in view of the above, Mr. as fairly submitted that the petitioner, however, had not approached the departmental authorities praying for consideration of a case for provincialization of her services. So, in view of the above position, Mr. Hawk submits that he be permitted to withdraw the present writ petition with liberty to the petitioner to approach the Director of Elementary Education, Assam, praying for consideration of a case for provincialization of her services under the provisions of the Act 2, 2017. So, prayer accepted. The present writ petition stands dismissed on withdrawal with liberty as prayed for. In the event the petitioner submits an application before the Director, Elementary Education, Assam, the said application be considered by the respondent authorities strictly in accordance with the provisions of the Act of 2017.
Bless one.
This order would take some time.
In the meantime, I have come across one communication. There's an instruction. from
Order.
the- Yes, my lords.
Order cog in the wheel.
The CM is instructed that a separate cadre for the protection of pipelines may be created because this is creating disparity of income, my lord. Issued by staff officer of chief control of the this BTP organization, my lords. It will. বুঝি পাবি যাবো আমি বুঝে দিচ্ছি বুঝে বেলেগ এটা বনাই দিয়ে পুলিচক কৈছে এই ভিটিপি মানুহ লগাই পেমেন্ট ডিসপ্যাৰিটি আছে সলিউশন হৈছে কপি পালো
So, you will not be encased as workers for the online work anymore.
Pilots.
So what is grievances left now?
Oh, what I was wanted pilots, can the government pilots?
We'll decide it. This is a communication of 27/6.
27/6, my lord.
We'll decide it before that. But Mr. We are not concerned with this. We are only concerned whether you will be given a higher scale. Where is that act? We have the act. But Mr. Learned Counsel for the petitioner. Also heard Miss A. Fukar, Learned Counsel Advocate, appearing for the respondent number 1 and 2, and Mr.
L. Sangdam.
S. Dr. Learned Senior Counsel, appearing for the Learned Senior Counsel, assisted by
L. Sangdam Lordship.
Huh?
L. Sangdam Lordship.
L. Santam Lordship. By Mr. L. Santam, Learned
Rules and Act.
Counsel. Counsel appearing for the respondent number 3, Oil India Limited. The petitioner society in the present writ petition, by way of instituting the present writ petition as a great form and direction upon the respondent authorities for enhancement of the wages of the members of the petitioner society in terms of the provisions of the Minimum Wages Act 1938. The petitioners have also prayed, the petitioner society has also prayed for a direction upon the respondent authorities to regularize or absorb the services of the members of the petitioner association as security personnel under the respondent in the Assam Police. Also, the petition society is projected to be a registered association of security personnel deputed for protection of oil installations and properties of the Oil India Limited. The petitioners project that they were initially engaged as village defense party members by the state police authorities and thereafter on the basis of a requisition made by the Oil India Limited, required to provide security to the oil pipelines and other oil installations. Also, the petitioner association project that its members were thereafter engaged.
My lords, I have been summoned.
Engaged as security personnel to the respective jurisdictional police stations. The petitioners project that they were initially given rupees 500 per month as pocket expense by constituting them to be village party, defense party members. It is projected that on a grievance being raised in this connection, the amount paid to them was increased to rupees 83.86 per day. However, the said amount was released to them as pocket expenses. The petitioners contend that the petitioner society contends that its members are utilized on a full-time basis by the Oil India authorities to provide security to its oil wells and its pipelines. Also, the petitioners contend that they had approached the respondent authorities for enhancement of their wages by reckoning the provisions of the Minimum Wages Act 1948. The approaches made by the petitioners not having being positively responded to by the respondent authorities, the petitioners had approached this court by way of instituting a petition being WPC number 7204/2015. However, they said writ petition on the prayer of the petitioner was permitted to be withdrawn by this court, while ordered it at 21/4/2016. However, with liberty to refile the same. So, accordingly, it is submitted that the grievances of the members of the petitioner society continuing to subsist, the petitioners had instituted the present writ petition with the reliefs as noticed, praying for the reliefs as noticed herein above. Also, Mr. D. Gogoi, learned counsel for the petition by reiterating the facts noticed herein above, has submitted that it is not disputed that the members of the petitioner association have been engaged by the oil authorities, through the jurisdictional police stations for providing security to the oil wells as well as the oil pipelines. He submits that the services rendered by the petitioner, although have been projected to be so rendered as members of the village defense parties, the petitioner submits that Mr. Gogoi submits that the engagement of the petitions was for the specific purpose of providing protection to the oil wells and pipelines of the petitioner of the Oil India Limited, and accordingly, the petitioners is found to have been rendering services solely for the Oil India authorities. Mr. Gogoi has further submitted that the Minimum Wages Act mandate that the persons engaged on a day-to-day basis is to be paid the wages as notified by the respondent authorities. However, by the competent authority. However, the state respondents, although being aware of the amount required to be authorized to the petitioners herein, have denied authorization of the minimum wages to the petitioners, and accordingly, the petitioners are accordingly, the members of the petitioners, members of the petition association are forced to serve basing on a very minimal remuneration paid to them, and that too as as pocket expenses. Mr. Gogoi, by referring to the notifications issued by the government from time to time, has submitted that the members of the petitioner association for the works done by them are, as per the notification issued by the competent authority under the provisions of the Minimum Wages Act, is as of 2024 entitled to receive rupees 10,975.86 per month. That is rupees 250 per day, and along with the applicable variable DA. Also, Mr. Gogoi submits that the petitioners, having been working for the oil authorities, although in the manner as indicated here in above, as highlighted here in above, the petitioners, the members of the petitioner association cannot be denied their minimum wages. Mr. Gogoi has further submitted, further submitted that considering the length of service rendered by the petitioners as security personnel for granting extending protection to the oil wells as well as the pipelines of the petitioner society of the Oil India Limited, the petitioners are entitled, the members of the petitioner society are entitled to have their respective cases considered for absorption against vacant posts in the police service of the state. He submits that such regularization is also mandated considering the long experience gathered by the petitioners in the field with regard to protection of installations. Also, in the above premises, Mr. Gogoi submits that the present petitions would require, submits that this court would be required to issue appropriate directions to the respondent authorities to pay to the petitioners, members of the petitioner society, their remuneration in terms of the Minimum of Wages Act, and so on. He further submits that considering the length of service rendered by the petitioners in providing security, in guarding oil pipelines and oil wells, the services of the petitioner is also required to be directed to be regularized against posts in the Assam police force. Again, commensurating posts in the Assam police force. So that's all. You want an enhancement of the under the Minimum Wages Act and regularization.
Regulation we have abandonment.
So Mr. Gogoi, however, submits that the prayer for regularization of the services of the petitioner made in the writ petition is not pressed in the present writ petition. What is that?
Something perhaps.
Your lordship, earlier.
And clarification from the central government.
Earlier I instructed,
Me,
not before you,
I don't have this sixth sense.
not before this. I'm appearing for respondent of 4 year lordship.
Me.
Mr. Doctor is here. I have to ask him. So what and what will this category also come in?
Yes, madam.
Why did you not give me? I just wasted my throat.
That is why I asked him whether central government is there. He
The
said,
matter was today fixed for delivery of orders. However, Ms. K. Fukan, learned government advocate, has placed on record a communication dated 14/2/2024 issued by the Office of the Deputy Chief Labour Commissioner (brackets Central), wherein it has been highlighted that the watch and ward employment as watch and ward has been included as a scheduled employment under the Minimum Wages Act, and the prevailing rate of wages under watch and ward category is rupees 832 for Julia Jan. Also, the said aspect of the matter was not placed before this court on the earlier dates of when the matter was being heard. Also, the same being irrelevant, this court defers the delivery of orders and requires Ms. Pukan to furnish a copy of the same to the Learned Counsel for the respondent number 3 and the counsel for the petitioner. The Learned Counsel for the parties shall make their respective submissions on the revelations made in the said communication dated 14/2/2024 and its application in the present writ petition, and with regard to its application in the present writ petition. Also, registry to list this matter again on what this one here? 12/12/2026.
lordship, I am appearing for respondent number 4. For 1 and 2, my friend Hugh. I'm for central government.
Oh, you're for CGC. Miss K. Fukan, CGC likhi bade. Uport S. Kumar, learned 1 and 2. Government advocate. 1 and 2. It's only deferred. What you thought is only deferred, not deleted.
It will be modified, madam.
Huh? I'll go. No, for further hearing query. Hey, further hearing query, further hearing. Mr. Chaudhary, I'm sorry, the judgments, it remain back in the. It's here, it's here. But Mr. A.Y. Chaudhary, learned counsel for the petition, also heard it was Mr. Ghosh, I suppose, A.K. Ghosh. Who knows it, Jordan? A.K. Ghosh, learned standing counsel of Panchayat and Rural Development Department, appearing for the respondents. The petition in the present petition has essayed an order dated 13/7/2023 by which issued by the Commissioner, Panchayat and Rural Development Department, Assam, terminating the contractual employment of the petitioner as engagement of the petitioner as accredited engineer of Rajatila GP Gaon Panchayat under Katigora Development Block, Kachar. The petition was engaged as an accredited engineer by the Commissioner, Panchayat and Rural Development, Assam, wide an order dated, wide a communication dated 2/3/2019. The petitioner joined his services as a accredited engineer, on contractual basis on 7/3/2019. Also, the petitioner, after his initial engagement, after his joining in the services, had executed an agreement with the respondent authorities on 7/3/2019. In terms of the said agreement, there was no period mentioned here, no, in the agreement.
The only clause is of clause 3, maximum of 364 days. Page 18.
So, in terms of the said agreement, the duration of the contract entered into with the petition by the department authorities was for the period as mentioned in the order of contractual employment, or maximum 364 days, whichever is more, unless terminated earlier. Also, the petitioner, after execution of the said agreement, continue with his services as an accredited engineer. Also, allegations came to be leveled with regard to the manner of execution of works in Rajatila, na? You were in Rajatila all along. Rajatila Gaon Panchayat under Katigora Development Block. Also, accordingly, the petition was called as a witness with regard to the allegations, with regard to a departmental proceeding instituted against one Nilutpul Datta, the accountant of Katigora Development Block. It is to be noticed that at the relevant point of time, a public interest litigation being PIL number 80/2021 was also instituted before this court, and in terms of the directions passed by this court, an inquiry was carried out by the jurisdictional deputy commissioner with regard to the said allegations. Also, on conclusion of the said allegation of the said inquiry, it is seen that an inquiry report was submitted in the matter by the deputy commissioner, which was forwarded subsequently by the government in the Panchayat and Rural Development Department to the Commissioner, Panchayat and Rural Development, for taking further necessary action in the matter. Also, in terms of the said inquiry report, it is seen that the petition was issued with a show cause notice on 6/5/2023, and therein allegations were leveled against him with regard to the irregularities as well as misappropriation of government fund in connection with the works executed in the Panchayat, wherein the petitioner was so engaged on contractual basis as accredited engineer. Also, the petitioner is found to have submitted his response to the said so-called notice via a reply dated 20/5/2023. The petitioner had in the said reply denied the allegations leveled against him in the matter. Also, the Commissioner, Panchayat and Rural Development Department, thereafter, on considering the inquiry report as well as the reply submitted by the petitioner herein, proceeded by order dated 13/7/2023 to terminate the service, the contractual engagement entered into contractual engagement of the petitioner as an accredited engineer of Rajatila GP. Also, the petition being aggrieved had instituted the present writ petition. Mr. A.Y. Chaudhary, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the petitioner's termination, that the termination of the contractual engagement of the petitioner was on an allegation of commission of misconduct by him during the discharge of his duties in such capacity. He submits that the allegation leveled against the petitioner is of commission of irregularities in execution of works which were allotted to him in Rajatila Gaon Panchayat and also a misappropriation of government money. He submits that the said allegations which have been leveled against him and which formed the basis of his termination by the impugned order has cast a stigma in him, and accordingly, the impugned termination of his services could not have been so done without first holding a departmental proceeding in the matter and affording to the petitioner a due opportunity of having to place his defense in the matter. It is submitted that the termination of the contractual appointment of the petition would have been permissible only after a proceeding has been so carried out by following the procedure laid down in the provisions of Rule 9 of the Assam Services Discipline and Appeal Rules 1964. Mr. Chaudhary has submitted that the respondent authorities, while passing the impugned order, had also not taken into consideration the contentions raised by the petitioner in his reply dated 20/5/2023, and accordingly, only on the basis of the allegations of misappropriation of funds existing against certain employees who were employed under the department in Rajatila Gaon Panchayat, the petitioner was also roped in the matter, and without, however, highlighting his role in the allegations so involved, the services of the petitioner came to be terminated in a most arbitrary manner by the order dated 13/7/2023. Mr. Chaudhary, in support of his submissions that the order of termination would have been in the light of the allegations leveled against the petitioner would have been permissible to be so terminated only by following the provisions of Rule 9 of the said rules of 1964, as relied upon a decision of a coordinate bench of this court in the case of Syed Masud Majumdar versus State of Assam and 5 others, reported in judgment and order dated 24/6/2025 in WPC number 1093/2024. Anything more, Mr. Chaudhary? This will do, or anything more? Any further submissions?
So further submission, Madam.
Per contra, Mr. A.K. Ghosh, learned counsel for the respondents, has at the outset submitted that the petition, that it is an admitted position that the petitioner was so engaged on contractual basis. He submits that the petitioner herein, at the time of his initial recruitment, had entered into a contract with the, had executed an agreement with the respondent authorities, and in terms of clause 3 of the said agreement, the contractual engagement of the petitioner was permissible to be so continued for a period of 364 days with effect from the date of execution of the said agreement. He submits that the respondent authorities had not extended the contractual engagement of the petitioner. However, the petitioner had continued in his services. The learned counsel, departmental counsel, further submits that the agreement as entered into by the with the petitioner, in clause 9 thereof, mandates the procedure to be followed for termination of the contract. He submits that the provisions of the Assam Services Discipline and Appeal Rules have not been incorporated in the said provisions and has not been incorporated in the said provisions. Also, he submits by referring to the show cause notice issued to the petitioner that the said show cause notice was so accompanied by the inquiry report submitted in the matter by the jurisdictional deputy commissioner. He submits that the petition was made aware of all the allegations as existing, as have coming on record against him, and it is basing on such materials placed before the petitioner that he had submitted his reply on 25/20/20. Mr. Ghosh further submits that the competent authority, having perused the inquiry report as well as the reply submitted to the show cause notice, as well as the show cause reply submitted by the petitioner dated so and so, had proceeded to find, had drawn a conclusion that the contentions raised by the petitioner in his reply was found to be not satisfactory. It is submitted that the petitioner had not brought on record any material to highlight that the allegations of irregularities, commission of irregularities with regard to the works, the execution of the works in Rajatila GP involving him, and as well as the misappropriation of money to be perverse. Also, Mr. Chaudhary, with regard to the decision relied upon by the learned counsel for the petition, the case of Syed Masud Majumdar, submits that a perusal of the said decision would reveal that the petitioner, that the agreement, contractual agreement, that the agreement for contractual service entered into with the said petitioner had incorporated therein the provisions of the Assam Services Discipline and Appeal Rules 1969, and accordingly the same not having been complied with, this court had proceeded to interfere with the said with the termination of the services of the said petitioner. So, however, he submits that in the contract agreement entered into with the petitioner in the present petition, the provisions of the act, the provisions of the rules of 1964 having not been incorporated, the petitioner having been given a due opportunity to place on record his stand in the matter by way of issuance of a show cause notice dated 6/5/2023, it is to be held that the principles of natural justice in this connection was satisfied by the respondent authorities, and accordingly he submits that the impugned order dated 13/7/2020 would not mandate an interference from school. Anything more? I've heard the learned counsel for the parties and also perused materials brought on record.
I relied on another judgment, Mal. I have last date occasion. There is
Which one?
1986 3 SCC 454. There is Sawai Singh versus State of Rajasthan.
Mr. Chaudhary has further relied upon the decision of the Honorable Supreme Court in the case of
Sawai Singh versus State of Rajasthan.
86 3 SSC 454.
Yes.
You have a copy of that?
Yes, my lord. Excuse me.
Para?
Only copy.
Okay. We'll complete it. Jharkhand.
Jharkhand and Kashmir.
What is-
Item 50, Your Lordship. There is an order of this Honorable Court. In the event the affidavit is not brought on record before the next date of listening, this court would consider grant of further time to file such affidavit only on payment of cost, which would be determined if so mandated on the next date of listing. Lordship, unfortunately, we could not file our affidavit, and government has filed an affidavit yesterday, Lordship. May I be granted a short time, my lord?
But what do I do with my order?
Lordship.
Hmm?
Actually, according to them, my lord, on the last date, our petition was not there, and their case is that we have considered their case. Lordship may hear the submission. BTC has done their part.
Once forwarded the names of
Okay. Heard Miss P. Learned Senior Counsel, Senior Counsel, Senior Standing Counsel, PC.
Lordship.
Also heard Mr. D. Dole learned for the petition of Standing Counsel, BTC. So you have filed.
They filed.
Mr. G.P. Learned Counsel, Learned Standing Counsel, Secondary Elementary Education Department submits that an affidavit on behalf of the respondents represented by him has been filed yesterday. Filed on date to deliver. Ms. B. submits that the BTC authorities had already forwarded the proposal with regard to the proposed provincialization of the services of the petitioner.
2017.
You're not denying that.
Yes. Case 56, man.
Submits that the District Scrutiny Committee, Pokraja District, has already forwarded the forwarded its recommendations with regard to the provincialization of the petitioner. However, she submits that you're filing an affidavit, or you're not?
Lordship will be filing in terms of.
Why, forget it, don't file.
No, Lordship.
Accordingly, she submits that no affidavit is required to be filed on behalf of the PTC authorities. Also, in view of the above submissions, a registry to list this matter again on, when you want to file a reply to the affidavit?
There are nothing.
Nothing. On 11/5, 11/5/2025.
26.
Along with the 11/6, 11/5.
26.
11/26.
2026. Where do
20, that he is there.
11/5.
Anything that comes out my fine, don't think I'm a judge. Anything come, he'll write. He'll write according to his thing. They have more experience in this line than
Lordship.
on 11/5/2026 for admissions, along with the affidavit filed by the respondent number 2.
Deeply obliged.
Not it will be. Relied on the following decisions. What decisions will it go in detail? I've heard the learner counsel for the parties and also peruse the materials available on record. Also, the materials brought on before reveal that in pursuance to the directions passed by this court, by division bench of this court in PIL number 80 of the 2021, the Deputy Commissioner Kachar had directed for a field level inquiry with regard to the implementation of the schemes under MREGA, MGNRE, Finance Commission, etc. during the period 2015-16 to 20-21 in Rastila Gaon Panchayat under Katigora Development Block, Kachar. An inquiry team headed by the Additional Deputy Commissioner Kachar along with other technical members was constituted, and the said committee had carried out field level inquiry with regard to the status of implementation of the various schemes in Rajtila Gaon Panchayat. Also, the committee thereafter, on conclusion of such inspection, had submitted its report in the matter to the Deputy Commissioner on 22/9/2022. Also, the Deputy Commissioner, on the basis of the findings of the said committee, had issued an order dated 23/9/2022, and therein had drawn a conclusion, basing on the inquiry report, that there are gross irregularities and misappropriation of government funds in schemes under MREGA program implemented in Rajatila Town Panchayat of Katigora Development Block, and the BDO, accountant of Katigora Development Block, and the accredited engineer, bracketed, that is the petitioner hearing, GRS and computer assistants assigned to Rastila GP were found to be involved. Also, the jurisdictional deputy commissioner, not being the appropriate authority for initiating disciplinary action against the above identified officials and field level functionaries, the report was forwarded to the inquiry report along with the other relevant documents were forwarded to the Principal Secretary, Panchayat and Rural Development Department, Government of Assam, for further action. Also, it is seen that the said inquiry report was thereafter forwarded to the Commissioner, Panchayat and Rural Development Department, for taking further action in the matter, and accordingly the Commissioner so-and-so wide issued a show cause notice dated 6/5/2023 to the petitioner. It has been highlighted in the affidavit filed by the respondents that the said show cause notice was also accompanied with the inquiry report as submitted by the technical committee, by the committee constituted by the jurisdictional district commissioner in the matter. Also, the petitioner is found to have submitted his reply in pursuance to the said show cause notice dated 6/5/2023, while his reply dated 20/5/2023. A perusal of the said reply would bring to the forefront that the petitioner had not dealt with the matter, the inquiry, the findings of the inquiry report, and findings in the inquiry report with regard to the schemes which wherein the petitioner was the schemes of which the implementation of which the petitioner was also involved. Also, the said reply having come on record, the Commissioner, Panchayat and Rural Development Assam, while order dated 13/7/2023 on a consideration of the inquiry report as well as the show cause reply, proceeded to terminate the services of the petitioner herein. The learned counsel for the petitioner has submitted that the petitioner's services could not have been so terminated without instituting a due proceeding, instituting a due departmental proceeding in the matter by invoking the provisions of Rule 9 of the Rules of 1964. Further, he submits that the services of the petitioner was not permissible to be so terminated. Submits that the petitioner was also entitled to the protections. Also, the said submission of the petitioner would now be considered by this court. Also, the rules of 1964 Rule 3 of Rule 1964 mandates that the rules shall apply to all government servants except persons in casual employment and persons for whose appointment and other matters covered by the special provisions are made by or under any law for the time being in force or in any agreement in regard to matters covered by such law or such agreement, and also to the members of the All India services. Also, the provisions of the rules of 1964 per se would not apply to the a person will have no application in respect of the services rendered by the petition as a accredited engineer on contractual basis. The said rules would have been permissible to be so applied in respect of the petitioner in the event in the eventuality, in the agreement executed between the petitioner and the the departmental authorities. The provision of Rule of 1964 was so incorporated therein. Also, it is seen from the agreement executed between the petitioner and the respondent authorities, no such incorporation of the said rules of 1964 is found to be made. Also, the agreement, clause 9 of the said agreement dated 7/3/2019 mandates as follows. Page 19, A2, 20A. Also, a perusal of the said clause would go to reveal that the services of the petitioner would be liable to be terminated in the event he is found to be involved in any act of indiscipline or misconduct. Also, in the present case, this court finds that the respondent authorities had issued a show cause notice to the petitioner and had, along with the same, also enclosed the inquiry report submitted in the matter by the committee constituted by the jurisdictional deputy commissioner. The petitioner accordingly was made aware of the allegations that were found, allegations of misconduct that was held to have been committed by him in the matter, and accordingly it was up to the petitioner to respond thereto by bringing on record cogent materials to highlight that the conclusions so drawn were either not applicable to him and or were perverse So this court, as noticed herein above, the petitioner in his reply had miserably failed to bring on record any such material. So accordingly, this court is of the considered view that the respondent authorities, having issued a show cause notice to the petitioner and along with all relevant particulars which would have facilitated him to understand the allegations leveled against him, and the petitioner having failed to submit an effective show cause reply in the matter, the principles of natural justice requisite to be followed is held to have been fulfilled in the matter. Also, having drawn the said conclusions, this court is of the considered view that the termination of the services of the petitioner was so done strictly in accordance with the conditions stipulated in the agreement for contractual service entered by the petitioner with the respondent number 7, wide the agreement dated 7/3/2019. So, having drawn the said conclusions, this court would now consider the reliance placed by the learned counsel for the petitioner and the decision of a coordinate bench of this court in Shayad Masood Majumdar. So, this court, on a perusal of the said decision, finds that the petitioner therein was also a contractual appointee. However, in the agreement executed between the petitioner therein and the departmental authorities, provision was made applying the a stipulation was made to the effect that the provisions of clause 9 This court has perused the said decision and finds that the same would not advance the case of the petitioner. Accordingly, a discussion thereon being made in the present order. Also, in view of the conclusions drawn by this court herein above, this court having found the termination of actual service to be so based on the materials coming on record, the respondent authorities having not considered any extraneous, having not affected the termination of the services of the termination contractual engagement of the basing on some extraneous considerations, and the considerations being german to the issue in hand, this court is of the view that the said termination of the petition would not mandate any interference from this court. So, in view of the above conclusions, claims made in the present petition stands rejected. Full stop. Baki hai, devoid of any merit. Business. It'll take some time to correct it. You'll get it by day after. Some corrections will do. Yeah, rules. 70. But Mr. Jay Borbi, on counsel for the petition. Just wait for 5 minutes. Let's get somebody else. Item number 53. Mr. Jay Borbi for the petitioner. Also heard Mr. D. Gogoi. D. Gogoi or I. Bothakur?
I Bothakur.
I. Bothakur, Learned Standing Council, Excise Department. What's up? The petitioner in the petition has presented a challenge to an order dated 30/4/2025 issued by the Commissioner and Secretary, the Government of Assam, Excise Department, imposing upon the petitioner the penalty of withholding of 1 increment with cumulative effect upon conclusion of a departmental proceedings instituted against the petitioner while issuance of a show cause notice dated 9/11/2020. The petitioner has further prayed for the consequential reliefs as would be available to her upon this court interfering with the impugned order of penalty. Also, the petitioner here while working as a superintendent of excise Corpeta, was issued with a show cause notice dated 9/11/2020, instituting a departmental proceedings against, basing on allegations which had surfaced against the petitioner during her tenure of service as a deputy superintendent of excise. Corpeta. Also, while the said show cause notice, 2 charges came to be leveled against the petitioner basing on an allegation of having permitted the shifting of a wine shop, IMFL of wine shop, without following the provisions in clear violation of the provisions of the Assam excise rules 2016. The petitioner on receipt of the said show cause notice had submitted an application seeking documents as set out therein for preferring an effective reply. However, the said application submitted by the petitioner came to be rejected, holding that they said that the documents as sought for by the petitioner had got no relevance with the allegations leveled against her. Also, thereafter, the petitioner submitted her written her show cause reply on 27/1/2021, also denying the charges leveled against her. Also, they said reply submitted by the petitioner not found to be satisfactory, the disciplinary authority of the petitioner by an order dated 7/1/2021 had directed for holding of an inquiry into the charges framed against the petitioner by the show cause notice dated 9/11/2020. For the purpose, an inquiry officer and a presenting officer came to be appointed. Also, the petitioner is found to have participated in the inquiry proceedings. Also, on conclusion of the inquiry officer submitted his inquiry report on 17/8/2021, and the same was forwarded to the petitioner by the disciplinary authority on wider communication dated 17/11/2021. The petitioner, on receipt of the said inquiry report, submitted her representation against the same on 2/12/2021. Also, the said departmental proceedings thereafter was not proceeded with. Also, a development had taken place in the matter. The petitioner, during the pendency of the said proceedings, had proceeded on had retired from her services with effect from 31/7/2023 on reaching the age of superannuation. Also, till the date the petitioner had continued in her services, the disciplinary authority had not passed any final orders in the disciplinary proceeding so instituted against the petitioner, why they said show cause notice dated 9/11/2020. Also, after lapse of around 3 years from the date the petitioner had proceeded on superannuation, the disciplinary authority, by order dated 30/4/2025, proceeded to dispose of the said departmental proceeding instituted against the petitioner by imposing a penalty of withholding of 1 increment, with cumulative effect on the petitioner. Also, further, the on the petitioner, full stop. Being aggrieved, the petitioner has instituted the present writ petition. I have heard the learned counsel for the parties and also perused the materials available. The issue arising in the present writ petition for consideration by this court is as to whether the provisions of Rule 7 of the Assam Services Discipline and Appeal Rules can be invoked by the disciplinary authority for imposition a penalty upon a delinquent after the delinquent had superannuated from after the delinquent had superannuated from had retired from his or her services on reaching the age of superannuation. Next, Rule 7 of the Rules of 1964 mandate that The penalties as prescribed therein be for good and sufficient reason and as hereinafter provided, comma, be imposed on a government servant. Apostrophe 2. Also, the term government servant has been defined in the provisions of Rule 2, bracketed E of the said rules of 1964. The said definition being relevant is extracted here in below. Page 428. It is a perusal of the provisions of Rule 7 read with provisions that read with the definition of the term government servant as occasioned in the provisions of Rule 2E of the said rules of 1964 would go to reveal that a penalty as contemplated under the provisions of Rule 7 can only be imposed upon a government servant. A government servant is a person, has been defined to be a member of a service and who holds a civil post in connection with the affairs of the state of Assam. Also, considering the decision of considering the definition of the term government servant as set out in the provisions of Rule 2E of the rules of 1964, this court is of the considered view that the penalty as contemplated under the provisions of Rule 7 would be permissible to be so imposed upon a government servant holding a civil post under the government of Assam. A person who has a delinquent who has superannuated from his services cannot be held to be holding a civil post in connection with the affairs of the government of Assam after he has so superannuated from his services. Accordingly, this court holds that the provisions of Rule 7, that the penalty as prescribed under Rule 7 would only be permissible to be so imposed upon a government servant who is holding a civil post under the government of Assam. The petitioner in the present writ petition on the date, the order dated 30/4/2025 was so passed by the disciplinary authority imposing upon the petitioner the penalty of withholding of 1 increment with cumulative effect, having already superannuated from her services, cannot be held to be a government servant anymore after the date of her superannuation from her services. Accordingly, the disciplinary authority, it was not permissible for the disciplinary authority to invoke the provisions of Rule 7 of the rules of 1964 to impose any penalty upon the petitioner herein. So, accordingly, this court is of the considered view that the order dated 30/4/2025 imposing the penalty of withholding of 1 increment with cumulative effect, which penalty is so prescribed under the provisions of Rule 7 of the said rules was so invoked was so passed without jurisdiction. Yes.
May I, my lord, from that stage, my lord, from the stage of inquiry report, my lord, I'm seeking liberty that, my lord, may give liberty to the department.
Sir, you hear me. You hear me out.
Yes, ma'am.
You hear me out.
Yes, ma'am.
Why are you so apprehensive? We are not fixated with something. We'll try to be balanced to the extent possible till we don't slip. I have a very short concentration problem. Short concentration.
I apologize, ma'am.
If it goes, it goes. It's manufacturing defect. Can't help it. You. Also, in view of the above conclusions, this court is of the in view of the above conclusions drawn by this court, the order dated 30/4/2025 stands set aside. Having interfered with the order dated 30/4/2025, this court notices that the disciplinary proceeding against the petitioner having been instituted prior to the date of her superannuation, the same after the superannuation of the petitioners would be covered by the provisions of Rule 21 of the Assam Services Pension Rules 1969. Also, the provisions of subrule A of Rule 21 mandates that The disciplinary proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall, after the final retirement of the petitioner, be deemed to be a proceeding under this rule and shall be continued by the authority by which it was commenced in the same manner as if the officer had continued in service. So, Rule 21 mandates the penalty that would now be permissible to be so imposed upon a retired employee against whom a disciplinary proceeding which was instituted prior to the date of superannuation and after his superannuation concluded. So, the penalty that would now be permissible to be imposed upon the petitioner would be the withholding of the withholding or withdrawing a pension or any part of it that the delinquent would be otherwise entitled to be authorized on his superannuation. So, this court, having interfered with the order dated 30/4/2025 on a technicality and it being evident that the proceedings instituted against the petitioner was required to be so continued under the provisions of Rule 21 of the Rules of 1969, this court provides that notwithstanding the interference made with the order dated 30/4/2025, it would be open for the respondent authorities to pass a fresh order.
If permissible, my lord.
Fresh order under the provisions of Rule 21 of the Assam Services Pension Rules 1969. At this stage, Mr. J.I. Barbhi, learned counsel for the petitioner, has submitted that in pursuance to a separate departmental proceeding instituted against the petitioner, the disciplinary authority has order dated
12/3/26.
order dated 12/3/26 has withheld the entire pension and pensionary benefits of the petitioner. And the said order is stated to be holding the field as on date, although the same is presently under challenge before this court in the proceedings of WPC number.
I do not.
Challenge before this court. Full stop. In view of the above position, the pension of the petitioner already having been withheld, subject to the outcome of the proceedings, wherein the order dated
12/3/26.
12/3/26, subject to the outcome of the proceedings in 12/3/2026, the respondents are at liberty to pass appropriate orders after the conclusion of the proceedings in WPC number so and so. Also, to liberty to pass appropriate orders invoking the provisions of Rule 21 in the present proceeding if the occasion so arises after disposal of WPC number of the proceeding instituted before this court assailing the order dated 18 Kibasilna. So, with the above observations and directions, the present
Liberty to, my lord, I may be given, my lord, opportunity of hearing also, my lord. If they pass.
No, there is no requirement of an opportunity of hearing. It will be just an order. We have interfered with our jurisdiction. They need not pass an order. If the occasion arises, they will do it. Charges are very serious against it. Technicality, we have done it.
Otherwise, in the fact, my lord, in the same place, he has already deposited amount.
Be that as it may, you have not taken a deposit. You have allowed, because we have seen cases when I was sitting in bench 4, the manner in which a wine shop is to be done.
Well, in the same particular place. Only
little bit change. The customers who they are serving are very dedicated people. They know one path. So if you change that thing somewhere, it will be very difficult for them. So they are very conscious of that. They are very conscious of that.
Same everything.
But the door changes, the customer suffers. So Mr. Bhattakur is very serious. Okay.
Obliged.
Dismiss. Yeah, Yes.
Orders.
Huh?
Some papers I have just received.
You give me materials to counter Mr. Khan, I'll allow your petition. Yes, Mr. Khan. Mr. Khan is very strong in this case today.
Yes. Still I have a strong lordship because
Hey, dear. Is this the way you work? There'll be a notice tomorrow in the cause list, Mr. Sharma. All the cases of honorary teachers that I have dismissed, the petitioners are liberty to come and make a mention of that. I'm restoring all the cases. What are you doing? Mr. U. Sharma, Mr. Enquire, tell me by tomorrow, day after. You continue, Mr. Anna.
Yes.
You also take a copy of that.
Yes.
Xerox Mr. A.Z. Ahmed,
Yes.
Learned Counsel for the petitioner, has placed on record certain documents to content that the petitioner was subsequently regularly appointed against the post of postgraduate teacher in English at Alamganj Higher Secondary School, right?
oh, Sapur Madrasa Higher
In
Secondary.
the writ petition, however, there is no such averment made on behalf made by the petitioner. In the writ petition, however, there is no such averment made. So, accordingly, in view of the above, the petitioner is directed to furnish copies of the said documents to both the Learned Counsel for the respondent number for Learned Counsel, Standing Counsel, Secondary Education Department, and the Learned Counsel appearing for the respondent number 7. The Learned Counsel for the respondents are required to complete their instructions in the matter and apprise this court about the same on the next date of listing. So, registry to list this matter again on 29? 29?
No problem.
29/4/2026 or 24.
Any date,
20.
I have no problem.
29.
Wait. Just simple instruction.
Simple instruction.
And you are the principal. He's
Yes.
drawing salary.
Lordship, just that is that order is under challenge. Lordship, just I have taken the charge of the principal, Lordship.
No.
Yes, he is drawing salary.
Regular salary.
Regular salary. If Lordship, I have some document, if your Lordship go through this, that everything will come in clear.
He has been now.
In that list, his name also there. In that order, his name also reflected.
This is the first page, Lordship. That is the post creation order. Your Lordship will find serial number 3, subject is English, 2 posts. And in the next page, your Lordship will find 2 teachers' name. Number 1, Lordship.
What is your name?
Samsul Haq Pradhani, number 1, English. This is the post approval order. And another English teacher, serial number 8, Jobeda.
And what is the name of the petition? Abdul Manna.
No, his name is not there.
Okay.
And
some documents.
7 January.
So show me the documents.
Yes. Huh? Extra copy at one side also. Yes. Thank you.
In the 96, April 96 document, 10/1 April 96, your name is not there.
Not only that, Lordship, I have given the last up to the last page. That is 95 and 97 also. Page 4. This is the inspector letter. His name is not there. And
Okay, Mr. Sharma, this is a very serious matter.
yes,
Initial appointment by the school authority, petitioner was appointed in place of Zobeda, Lordship. Subsequently, Lordship, he has been adjusted.
Adjusted when?
Lordship, though it was in 2000, Lordship.
How can you be given? Where is your recruitment? Where is your selection appointment?
Lordship, one order just for my satisfaction, Lordship. 7 January
You
2000.
took your satisfaction.
Lordship,
Satisfy this court also.
No, 7 January 2005, Lordship. Can you come? Yes, this letter. Yes, Lordship. Here, Lordship, all the 8-person, Lordship. There are 8-person.
So show me when you were approved on 10/1/96, your approval. Where is that letter dated 10/1/96?
Lordship, only this
You have
letter.
given me the letter dated 10/1/96.
no. No, yeah, this is 12/3/96. This is the post sanction order.
10/1/96, what approved
And
by
to-
and have been approved by the government letter number 10/1/96?
No. That letter is not with me.
Lordship, here the
Both of you, give your documents to Mr. Sharma.
yes. His name also reflected there in there.
Yes, very much.
Yes.
We'll cancel his appointment also. Don't worry.
Direction may be given to furnish a copy to us that petition.
The matter, first up, Mr. A.K. Azad, A.Z. Azad, A.Z. Ahmed, learned counsel for the petitioner. Also heard Mr. U. Sharma, learned standing counsel, Secondary Education Department, and Mr. M. Khan, learned counsel appearing for the respondent number 7. The petitioner in the present writ petition, appearing for the respondent number 7 on caveat query. The petitioner in the present writ petition has presented a challenge to an order dated 27/2/2026 issued by the Director Secondary Education Assam, allowing the petitioner hearing the respondent number 7 herein to hold the charge of the post of head principal of Sapar Romari Higher Secondary School until further orders with effect from 1/3/2026. So, during the hearing of the petition today, this court had required the petitioner to demonstrate that he was appointed on a regular basis as PG, postgraduate teacher in English in the said school, as from the materials brought on record in the petition, it was evident that the petitioner was so engaged by the managing committee of the school on honorary basis. Full stop. The matter, the learned counsel for the petitioner in response to the said query raised by this court had placed on record certain documents wherein it is been reflected that the services of the honorary services of the petitioner was subsequently was subsequently regularized by the government by accommodating him against a sanctioned vacant post. The said issue was disputed by the learned counsel for the respondent, who also had produced certain documents to support his case that the petitioner's services was never provincialized at the initial stage. Also, the disputed questions having come on record, this court requires both the learned counsel for the petitioner and the learned counsel for the respondent number 7 to furnish a copy of the documents relied upon by them to Mr. U. Sharma, learned standing counsel, Secondary Education Department. Mr. U. Sharma shall have the said documents verified by the verified from the office of the Director of Elementary Secondary Education and apprise this court on the next date of listing about the service particulars of service status of both the petitioner and the respondent number 7. in the school in question. So, the Director of Secondary Education shall in writing inform this court of the findings that would now be arrived at by her basing on an examination of the documents as produced today before this court by the learned counsel for the petitioner and the learned counsel for the respondent number 7, as well as the service particulars, actual service particulars of the petitioner and the respondent number 7. True, and submit the same before this court through Mr. U. Sharma, learned counsel for the petition, learned standing counsel, secondary education, on the next date of listing. Registry to list this matter again on when? 29. Okay. We'll have it on 30. We give you one more day. On 30/4/2026. And give the documents today itself and give a set of documents here also. Copy, download it.
My set lordship may keep in the record. My set may keep in the record. I have an.
No. You write here.
Yes.
Respondent, each page you write respondent or petitioner.
Yes.
And then give a copy. And you give it to her, he'll keep it. Good, thank you. You are a savior for the honorary teachers. People will remember you for that.
No, because
And Mr. Sharma, if the department has done that, take it from me, there will be a notice in the notice board.
I will take
For
that.
further hearing,
Regarding that, I will.
If you have regularized honorary appointments in this manner, then it will be applicable. Dombodor, Kolita, that all those cases gone. Yesterday did I dismiss that matter yesterday? No. That honorary teacher yesterday? I think I adjourned it. I'll get everything and I'll pass orders. Go. Do. Negative and you'll argue negative equality. I'll look into it. Too much. Yeah. And you gave Mr. Khan, Mr. Ahmed, give the papers today itself.
Copy of rectification may be furnished to us.
Yes, everything. You give your caveat copy also. On that, no.
hard copy I have to receive.
Which one?
Hard copy.
No. What you have given to this court today, give that.
There are some other documents.
Forget it. What is there today, only give that. Yes, Mr. Losko.
Like to.
Withdraw.
Yes.
To do it liberty to approach.
Okay.
The appellate authority.
Mr. M.H. Loskar, learned counsel for the petitioner. Heard Mr. M.H. Loskar, learned counsel for the petitioner, and Mr. A. Fukan, learned standing counsel.
Elementary education.
Elementary education department. Mr. Loskar, after attempting to argue the matter at some length, submits on instructions that he be permitted to withdraw the present petition to pursue the claim. Permit the petitioner to withdraw the present petition to pursue his claim for provincialization of his services under the provisions of the Act of 2017 before the respondent authorities and or before the jurisdictional educational tribunal as may be advised. So the prayer is not objected to by Mr. A. Fukan, learned standing counsel, elementary education department. Also, in view of the above prayer made by the petitioner, the present petition stands dismissed with liberty as prayed for. Next one also same. 12, 10,
11 and 12.
11, 12.
Obliged. Deeply obliged.
Mr. Loskar, please don't mind. I also feel sorry, but see, if I do that, there is always a fear that it will go, knowing the education department, it may go and affect some person who would be taken by surprise. If you had implemented them, it would have been a different issue altogether.
Otherwise, also don't mind, your lordship. Generally, this course gives very balanced judgments.
I'm not a balanced man.
Balanced.
I'm a very unbalanced man. But thing is, I think I have to think of that also. I can't limit it to this. No worry. Next time, better case.
Oblige, lordship.
Yes.
This petition challenges a notification in the earlier round in the affidavit opposition. An order was annexed at page 103, giving us certain benefits. 20 WPC 2093. We are challenging the
yes.
enhancement
Ms.
from
Musari.
14,000 to 20,000.
No, so they were appointed under a scheme. So now they want this regularization, and now they have challenged the notification where their grade pay was enhanced, your lordship.
They are still under a scheme.
Still under a scheme, and here it is.
They have come before us.
Lordship.
Ms. Mushahari.
Lordship.
They have come before us. We'll examine.
Lordship.
They're not passing any orders asking you to pay them higher pay today itself.
Lordship.
But Mr. B.P. Bora, learned counsel for the petitioner, also heard Ms. D. Mushahari, learned standing counsel.
Secondary, your
Secondary
lordship, 1,
Education
3 and 5.
Department.
1, 3.
And Mr. A. Chalia, learned standing counsel finance department, and Mr. B. Shaw, along with Mr. B. Shaw, learned standing counsel accountant general bracketed A&E Assam. The petitioners in the present writ petition who are working as part-time ICT instructors under the Dr. Banikanta Kakoti Computer Literacy Program have assailed a notification dated 25/2025 issued by the Secretary to the Government of Assam Department of School Education, enhancing the wages, the honorarium of such, enhancing their honorarium from rupees 14,000 per month to 20,000 per month, and a service guarantee up to the age of 60 years.
Lordship, that part I have not challenged in my prayer also.
This is there in the order itself. If the order goes, I can't keep half. I'll have to set aside everything.
Not sure.
Also, the petitioners have contended that the enhancement of their salary is not in accordance with the minimum wages a person is not in connoissance with the minimum wage a similarly situated regular employee discharging similar nature of duties is drawing. Also, issue rule returnable 4 weeks. Issue rule de returnable 4 weeks. Miss D. Mushahari, learned standing counsel, and issue notice returnable 4 weeks. Mr. Mushahari, learned standing counsel, Secondary Education Department accepts notice on behalf of respondents number 1, 3,
And 5.
and 5. Who is for this industry and commerce and IT?
Morning.
Also. Mr. A. Chalia, learned counsel accepts notice on behalf of respondent number 6, while Mr. B. Sharma, learned standing counsel accountant general A&E accepts notice on behalf of the respondent number 7. No formal notice is to be and so on. Petitioner to take steps for service of notice upon respondent number 2 by way of speed post. Steps within 6 weeks, steps within 3 days, 3 working days from today. The respondents on the next date of listing shall bring on before the next date of listing shall bring on record their respective stance, comma, if so advised, by way of filing an affidavit. Registry to list this matter again after 6 weeks. But you get it, we'll not keep it. That's why I've given you 6 weeks so that you get it, then we can, if it is there, they get it. If they're not finished.
No, so they have been extended only till February 2026, Your Lordship.
So now this.
So whether there has
Now,
been
now
any,
60,
yes,
60 and
60 years,
Lordship, 60 years, Your
No.
Lordship, but
And
yes, Your Lordship.
60.
Lordship and
She was thinking something else. It comes out. What is that?
Lordship.
What is the big thing there?
Extended till,
You issue a corrigendum tomorrow,
Lordship,
Mr. Bora will now file another one. Better. You should help everybody out like that.
Lordship.
Yes, Mr. Bora. That's how the department should help. You get your instruction
Lordship.
and also apprise this court whether a scheme employee would be covered by the judgment of judges.
Lordship.
And I am also relying on other RT rules.
This court understands little bit. So I'll go little bit.
It knows it all.
No, I don't know. But that is a good perception people will have. It's a good perception. It's good for me. Yes. Imran?
May I please, Your Lordship? Lordship, we have taken the steps today morning.
Your name?
J.A. Sikdar.
Huh?
J.A. Sikdar.
J.A. Sikdar. How are you related to A.R. Sikdar?
He's my senior, nothing else.
Nothing else. Okay. But Mr.
J.A. Sikdar.
J.A. Sikdar, learned counsel for the petition. Mr. Sikdar submits that the steps for service of notice upon the respondents number 4 and 5 has been taken today. Also, registry to verify they said same and proceed in the matter accordingly. Also, registry to list this matter after 6 weeks on a date to be fixed by.
Obliged, Lordship.
Deeply obliged. Eight.
None appears for the petitioner on call. For the ends of justice, Ms. M. Score, learned standing counsel.
Elementary education.
Elementary
Lordship.
education is present. For the ends of justice, registry to list this matter again after 4 weeks on a date to be fixed.
28.
28.
Yeah, I am.
28. You are there, Mr. Muzumdar. Yes.
Your Lordship, we can receive the last order, 26.3. Fine.
Earlier occasion, Lordship,
Okay.
I had received incomplete instruction, Lordship, so I could not.
We are not. Who gave you incomplete instruction? Call her.
Today I had received another one, Lordship.
Last chance was given.
Yes.
Yes. In such matters, ask your seniors to appear so that I can pass some very harsh orders.
22 method, Your Lordship. Retired on 19.
In this matters, you must ask Mr. Katoniar, Mr. Chisti, Mr. Kaushik to appear. Senior. Oh. She is not senior. She is junior to you, at least in this department.
সিহঁতক কিবা দিব দিছিলে দিয়া নাই নিউ পেঞ্চন ফাণ্ডৰ যিখিনি লৈ আছিলে সেইখিনি ৰিটাৰ্ণ কৰিবলৈ কৈছিলে ট্ৰেজাৰী সেইখিনি দিয়া নাই আপোনাৰ মিটাৰটোত এইখন ইনষ্ট্ৰাকচনৰ মতে আগতে নিউ পেঞ্চন ল'বৰ আণ্ডাৰত পাই আছিলে জমা দিব দিছিলে
You had withdrawn some, Mr. Muzumdar, you had withdrawn NPS amount.
Yes, 4 lakhs. That is, I have already stated in my representation.
That you have deposited back. You have not deposited
no,
that amount.
No.
You're getting a provisional pension? No.
No. Only NPS 4 lakhs at the time I have received.
Miss S. Standing Council, Elementary
Lordship.
Education has placed on record the instructions received by her. Placed on record a communication dated 24/3/2026 issued by the Deputy Inspector of Schools to the Director of Elementary Education, Assam. Also, along with the enclosures there, Ms. Kaur to submit a copy of the said communication to Mr. Mojumdar. Also, registered to list this matter again on 11/5/2026. Mr. Mojumdar is permitted to make his submissions after perusing the said communication dated 24/3/2026. Copy of the communication dated 24/3/2026 is kept on record and marked as X for the purpose of identification.
You must have me today.
Today.
Number 2.
Lordship, I am appearing on behalf of KDB Lordship. She just left the court because of her headache, Lordship. So, Madam, may I Lordship?
Do you want to file a reply to the affidavit?
Yes, Lordship, we have replied.
You'll file.
Now, Lordship, we
No
will
file.
file, Lordship.
Huh?
We will file, Lordship.
You will file. The learned counsel for the petitioner submits that she be granted a week's time to file a rejoinder to the affidavit filed by the respondent. Prayer accepted. Registry to list this matter again. Yeah, 14/5/2026.
So, we have another 3 matter, Lordship. Item number 30, 32, and 56, Lordship.
Oh, 30.
30, 32, and 56.
Okay. 30, 32.
And 56, Lordship.
Noted.
Obliged.
Yes, noted. All the 3 cases dismissed for default.
Lordship.
Yes, where is your counter?
Lordship, here the counter on behalf of RMSI cannot be given because the managing director of Authorised Sangathan, it's a completely different directorate. Lordship, only they can, and I have seen the record, Lordship. Notices were issued, but no AD has not been received back.
On the prayer of the learned counsel for the petition, we'll have Ms. Devi here. Registry to list this matter again on 28/4/2020.
Lordship.
So, he ordered it in last round. So, last chance was given to them to file my lord.
Lordship, here earlier submission was in this matter, Lordship, only. Because
not that here that submission.
Yes,
That's
Lordship.
confused. See, you could confuse this court so easily. So confused from where is ours? Okay, fine. Mr. Devi is also. I thought there is something we'll have to hear. Yeah. Yes.
Lordship, the Adakha Vidya Sangathan was formed in 2021. Before that, RMSA was in charge of the Adarsh Vidyalaya. Thereafter, Lordship, everything is conducted by the Adarsh Vidyalaya Sangathan, and it's a separate directorate, Lordship.
In the state?
Yes, Lordship.
Are there a party?
Yes, they have been made.
Kindly, my lord,
Respondent number 3. And Lordship, office record shows that steps were taken, but no AD was received back.
My lord,
complete. Service
Complete. That's in that manner.
Service is complete. So you have nothing to say here.
Lordship, RMSA have got nothing to say.
You also have nothing to say. Also, It is seen, the learned counsel for the respondents, Mr. B. Chaudhary, learned standing counsel, RMSA, and Mr. B. Kaushik, learned standing counsel, Secondary Education Department, have submitted that the respondents represented by them are not connected with the issues raised in the present writ petition, and the said issue is to be dealt with by the respondent number 3, that is the Managing Director, Adarsh Vidyalaya Sangathan. This court finds that the notices have been served upon the service of notice upon respondent number 3 has been held to be complete by this court. Has been held to be complete. Your file. 4 to 6. 4 to 6.
4 to 6 are file, madam.
Also, Ms. N. Chaudhary, learned standing counsel, BTC, has submitted that an affidavit on behalf of the respondents represented by her has already been brought on record. Also, in view of the above, registry to list this matter for a final consideration in the admission column, admission stage on when?
On a needed, madam.
14/5/22.
Difference key.
Yes, where is your affidavit? Standing counsel, secondary. Matter pertains to pensionary benefits. You are not involved. Ms. P. Das, Mr. U. Sharma. Mr. A. Solia, then E. Musahari. Yes. Okay. Yes. Thank you for the information. Thank you for the information. You were taking time on repeated occasions. What have you done after that? It is seen from the orders passed by this court in the present proceeding that the
10 days time may be granted, Your Lordship.
the respondents in the Secondary Education Department have been taking time on all the dates of listing, praying for filing of an affidavit. However, no such affidavit is being found to have been filed, although the matter is pending since 2023.
23, no?
Also, yes, how much cost?
Your Lordship, 2 days time may be granted, Your Lordship.
Ms. P. Sharma Das submits that the affidavit in the matter would invariably be filed on or before 27/4/2026. In the even the said affidavit is not filed on or before 27/4/2026, this court would pass appropriate orders as may be deemed fit and proper in the matter on the next date of listing. Registry to list this matter again on 27/4/2026.
Deeply obliged to it,
This time, madam,
Yes, Your Lord.
undertaking.
I pay for the AG, man.
Mr. B. Sharma, learned standing counsel, AG, is present. Yes, you have got the records.
They have sent some documents, my lord, but যেটা আপনার কাটে দিয়া আছে appointment letters গুলো দিয়া আছে এখানে পোস্ট কি দেখেন তুমি কি কইছো সেইখিনি দি পাঠাইছে না Those documents are already on record, my lord. Nothing new.
Okay. Yes, what is your case?
My lord, actually what happened, my lord, after recommendation of the state level committee, my lord, I was appointed on compensatory ground. My
Who appointed you in Science College?
Science college in the principal, my lord.
So that was not an appointment by the government.
Comment, my lord. This is
Where?
there is the Gauhati of Assam. This was later, it was, by the kindly student, 14, page 14. The principals, to the principals, Jorhat Science College, Jorhat, from CRP Mojumdar, Deputy Secretary.
Okay,
of the
okay.
Gauhati. That is the last occasion he
So,
raised the.
yes, Mr. Das.
My lord.
He's a government employee.
Yes.
You have transferred him to Jorhat Institute of Science and Technology.
No, my lord.
When that science college, science school or science college?
Full play.
Science college.
Science college.
My lord.
Is the-
Science college was transferred in that society mode. You created that. He was a government employee. He went as a government employee.
No, my lord, if my lord kindly see the appointment letter, my lord.
That is
Page-
compassionate grounds.
Compassionate, this is temporary on a compassionate, my lord. He has been appointed as a temporary employee. Then page 15, my lord.
How can you appoint somebody as a temporary employee under compassionate grounds? You cannot. SLC had.
But my lord, principal has appointed and
We
he has
are
not challenged that
concerned with the
order.
Principal.
He has not challenged that order. And my
Okay.
lord, and later
Okay, do you
subsequent,
want-
subsequently.
That is the only ground.
No, my lord, subsequently, my lord, subsequently, kindly see page 46 of their affidavit in reply. Appointment letter is of 2010, then subsequently on 2018. It says that with reference to subject cited, I'm directed to say that the pursuant to government notification of so and so, restriction of so and so, the service of the following 6 numbers of incumbents are hereby regularized with effect from 2016. That also has not been challenged, put to challenge, my lord. He has accepted that, petitioner has accepted that. Now, my lord, now
Where is
without
the impugned order?
without challenging anything, my lord,
Impugned order
he has
is page
come before this
33.
honorable court seeking, my lord, the benefit.
Yes.
My lord.
Yes.
My lord, my limited grounds are these 2-3 grounds are only that, my lord. That first, my lord, his appointment was, as mentioned in the document, his appointment was temporary by the principal of that science
Why
college.
do you go to the second annexure? Go to the first annexure.
First annexure was, my lord, page number 14. 14 talks about the deputy secretary has directed
No.
the principal to initiate.
No. It says that the state level committee had recommended the name of Prabhajyoti Dutta, son of so and so, for appointment in grade 4.
Yes, ma'am.
Vacant post of 2023 in Jorhat Science College, Jorhat. You are therefore requested to initiate after checking roster so and so, so and so. So this appointment is in pursuance to SLC. It cannot be an appointment other than a regular. Settled position of law. Decisions of this court also.
Lordship's order is also.
But the documents says, and he has also accepted, my lord.
What he has raised,
My
my lord.
You give me what you have to give.
what my submission is, my lord, that unchallenged order cannot be indirectly questioned in a letter.
Which is the unchallenged order?
These 2 orders, my lord. First, the initial appointment order, and subsequently the regularization order, which is given effect to from 2016.
Which order? Which order?
First one is this, where he says that it's his appointment is temporary. Page number 15,
That I'll
annexed
handle.
to, then
That
my
I'll
lord,
handle.
then
Next one,
page number 46, my lord.
46.
46 of their affidavit reply. Because after having been appointed, why would, my lord,
This also, these are the only two objections you have.
my lord?
Nothing else.
What?
Anything else, Mr. Das?
No, that is my lord.
Okay. Dekha.
And my affidavit is there, my lord. Affidavit is also there, my lord. My affidavit is there, my lord. So there.
Affidavit is not on record.
That is there. That is there.
Affidavit. Oh, yes, you have filed an affidavit.
Yes. Page
But the
34.
learned counsel for the parties said something. Hearing remains inconclusive. Registry to list this matter.
Eight five need you.
Good. 6-5. We are allowing the repetition.
My lord, those two grounds are not in the affidavit. My lord, may record those two grounds, my lord. This unchallenged, this one. That is not, I have pleaded in the affidavit, my lord. Yes, my lord.
Page 14 and page 46.
46 and page 15, my lord.
50.
Those two orders has not accepted by the petitioner, did not challenge. Yeah, my lord. My submission was, my lord, that unchallenged government order cannot be indirectly challenged. Regular service with effect from 16 है सर या फिर मैंने compulsion
My reply is that the initial appointment being, this is nothing big. Only thing is which period will be taken into consideration for MAPC.
My lord.
His initial appointment being on compassionate grounds, it cannot be anything else than a regular appointment. If that be so, the period for which has to be reckoned will have to be reckoned from page 50. They are all, that's why I don't want to pass an order.
Then court date may be given 30. Page 16 or
See, that is
oh no sorry.
that is all sitting and sleeping. Understood, na? You are getting to sit, now you want to sleep. Okay. Yes.
Here, my lord. Lord, our affidavit is not there. Perhaps my lord, it will not be required also, my lord, because their only claim is based on an observation made by this honorable court in a judgment, my lord. And they have challenged the recruitment process, my lord.
That earlier judgment,
Yes.
equalization.
Rationalization of the marks. Based on that, my lord, they have challenged the subsequent recruitment, which now already has over. This recruitment is over.
There was another matter. And this is what I...
There was Buzarbura's order, and based on that order was passed by my lord Justice Mehdi in their repetition. And pursuant to that observation, that paragraph, my lord, they have challenged the subsequent recruitment process.
No, that I got.
There was no stay. The recruitment process is now over.
You implement the persons who have been appointed.
Like there was a connected contempt petition also which has been closed, my lord. Because as there was no mandamus in this petition, my lord.
No mandamus,
No
no
mandamus.
direction was.
It was
an
an observation.
Yes. Mr. Ali.
My lord, for implementing the parties, I am not equipped with the list of appointed candidates.
Okay, forget it. Now show me, where is the mandamus issued by this court that it has to be done in this manner or no? Or not? Or not to be done? They were candidates in the recruitment process.
No.
They were not.
No.
You had not applied in pursuance to the advertisement, Mr. Counsel?
No. Applied.
Applied. Where have you said?
Prior to our apply, we have filed this writ petition.
Okay, where did you say? Where is the advertisement?
My lord,
Advertisement at page 57.
two advertisement, 57 and another on 63, man.
What is the last date of the advertisement?
It was 2nd of January 2024. Oh, sorry, 2nd of February 2024.
2nd of April.
2nd of February 2024.
So you all applied in pursuance to this
My lord.
and participated in the selection process. Okay.
My limited grievance is that if there is a not a mandamus but an observation from this honorable court that the number of the annual stream should be rationalized. That has not been done. That is my limited prayer, my lord.
I don't. In fact, my lord, the government, in order to mitigate these issues, my lord, that page 3, third page, my lord, kindly see, has constituted a committee, my lord, comprising of all the controller of examinations of the universities, and the university examiners have undertaken some process, my lord. So,
but this finality has not been.
And nothing has been done.
Till now.
During this contempt proceeding, my lord, that was done, my lord. Then, my lord, thereafter, my lord, the universities.
Why was the contempt proceeding closed?
Contempt proceeding because, my lord, there was no mandamus at. And the universities have not acted upon now, as of now. The university members have not acted upon. The request was made to the universities so as to devise a mechanism how to rationalize these marks. Because that is the universities who has to give us the figures.
Yes.
If your lordship comes to the orders of the Honorable High Court, my lord.
48, para 33.
My lord. From the order, it is clear that the candidates who.
Yeah, we accept this position.
My lord.
That semester system that we undertook and the young kids here who the year system which we undertook and the young kids here who has come through the semester system.
Yes, my lord.
They score very high marks.
Yes.
We got very low marks.
Yes, my lord.
So we can project that to show that we are not that we were not less intelligent, but the marks were not being given. It's a good ground. But the thing is, there is no direction here.
My lord.
We cannot hold that the respondent authorities would have to keep their recruitment process in abeyance till the conclusion of the process of rationalizing or the formulation of the procedure to rationalize.
So may I pray one thing? Since the matter has been taken up by the respondent authority, let them expedite it, my lord.
Okay, we'll close it then with petition. But Mr. You want me to close with that observation?
My lord, and I may be intimated.
Intimation will not be there.
Otherwise, how I will know that
You
in which way they.
You approach them. They will let you know. Mr. Mr. S. Ali, learned counsel for the petition. Also heard Mr. B. Kaushik, learned standing counsel.
Elementary.
What abuse what's going on? Heard the learned counsel for the parties of length. Today I will not disturb them much. They are there. Registered to list this matter for further hearing on Thursday. No, Thursday. What does it mean? 24 ko Friday. By slip ko I'll pass the order on Friday.
Deeply obliged.
Lordship here, Lordship.
Mr. Bonig, after a long time.
May it please your Lordship.
You have deserted this court.
My Lordship. The short campus is whether the
I have not responded to the court's query.
I could query also Dibrugarh University whether it is.
I thought that you have deserted this court. Not seen you for a long time. Mr. D. Upamanyu, learned counsel for the learned standing counsel, Higher Education Department submits that he be granted further 2 weeks' time to place on record the instructions received to receive instructions with regard to the issue as to whether the qualification of MSc in Geographical Information Science can be considered as an allied subject to geography. He submits that the said instruction is being processed and queries in this connection has already been issued to the registered Dibrugarh University. So accordingly, registry to list this writ petition again on 5/5/2026. By the next date of listing, the learned standing counsel, Higher Education shall complete his instructions in this connection and place the same before this court. Register is nothing not far away. A phone call will do. And this is a very small issue.
Yes, Lord.
Huh?
Yes.
Get it next time. Or we'll have to do. We have to wait for a day. Because I'm not an expert in geography. So we'll have to rely on that.
Highly obliged.
Mr. Purkhasto, you are back.
Lordship, yes. Lordship, this matter will need some time to complete our instruction and to file affidavit, Lordship. Okay. All the petitioners belong to 6 schedule area. They are claiming relaxation from the ambit of 1917 Act, Lordship. They are not qualified otherwise.
Five and seven is?
No, additional director of half long. That to Malgat.
Yes. Where is your affidavit? File.
I'll go look. Yes, sir.
You have got a copy?
They are filed in my lord WPC 1968.
Okay.
1966.
Yes, Mr. Doctor. What about your affidavit?
Lordship, for that, Lordship, we need some time.
The cancellation was by the You or by you? By the state? Yes, why did you cancel it? You have filed a reply also.
Yes.
So you don't want to file an affidavit, we'll proceed to take it up for file because people are suffering.
Lordship, we will file affidavit that
You have been taking that,
instruct-
saying that for the last nearly 1 year now.
no, yesterday I have got the file and I have also discussed with the officials, Lordship. To some instruction they have provided, but it will not sufficient.
So this is a default on the part of the councils who were handling the brief before you.
No, Lordship, that time this is not my submission. So I may be granted at least 10 days time so that I can
Give me
compile.
a date by which you will file the affidavit.
Lordship.
Otherwise, it will be 50,000.
Yes, Lord. Lordship, first week of May ended.
Mr. C. Sharma, Learned Counsel for the NC Hills Autonomous Council, submits that an affidavit on behalf of the said council has been filed in WPC number 1968/2025, and the same would cover the issues arising in WPC number 7/2025 and 6915/2024, right? So, Mr. P.P. Dr. Learned Counsel, Learned Standing Counsel, Secondary Education Department submits that the affidavit on behalf of the respondents represented by him would be brought on record on or before 4/5/2026. In the event the affidavit on behalf of the respondents represented by Mr. P.P. Dr. is not brought on record on or before 4/5/2026, this court directs that such affidavit would be permissible to be so filed by the said respondents only on payment of a cost of 25,000 with the registry. The manner in which the said amount is to be utilized would be so decided by this court on the next date of listing in the event the affidavit is not brought on record by 4/5/2026. Registry to list this matter again on 4/5/2026.
Lordship, can it be 6/5?
Question. Okay, 6/5. Osis question, huh? Osis is our question. 15,000 kori. And it will be recovered from your offices now. Mr. Cholia, what are you waiting for? 41.
In this case, the government respondents took time for the last 3-4 times for affidavit. They said instructions are there, but affidavit is not coming.
Yes,
So
Ms.
I will
Kumar.
pray if you will also give them time today also.
Instruction received, Lordship. I am.
That too you received on 16/3.
Yes, Lordship.
Yes.
Another council was appearing, Lordship. Then I'm praying for 3 weeks time to file.
Then
affidavit,
tomorrow
Lordship.
there will be another council, a senior council
Lordship,
to
I
come
will
to
file-
court
I will
only
file my
to
affidavit.
see that the matter is adjourned.
No, Lordship. I will file my affidavit.
Lordship will fix that after 2 weeks. And
Sufficient.
if the affidavit is not filed in the meantime, then it will be taken up.
Heard Mr. D.P. Cholia, Learned Counsel for the petitioner. Learned Senior Counsel for the petitioner, assisted by Ms. M. Roy, Learned Counsel for the petitioner. Also heard Ms. S. Kaur, Learned Counsel for the Learned
Elementary.
Standing Counsel, Elementary Education Department. It is seen that the notice in the matter was issued on 6/2/2025, and thereafter on every date of listing for the last around 1 year, the respondents have been taking time, different councils appearing for the Elementary Education Department have been taking time for filing of the instruction, for filing of an affidavit in the matter. However, no such affidavits have been filed. Also, Ms. S. Kaur, Learned Standing Counsel, Elementary Education Department takes the responsibility to file an affidavit on behalf of the Elementary Education Department on or before 5/5/2026. As Ms. Kaur has taken the responsibility to file the affidavit on or before 5/5/2026, this court restrains itself from passing any further adverse orders in the matter against the departmental authorities. for not filing the affidavit. However, on the next date of listing, in the event the affidavit is not brought on record, this court would consider passing of orders imposing upon the respondents exemplary cost for having taken repeated adjournments in the matter, however, not keeping the commitment to file an affidavit. Also, registry further, the court would proceed to consider the issues arising in the petition basing on the materials already brought on record. Accordingly, registry to list this matter again on Imanta Ikusilu?
Can it be on 11, Lordship?
5-5.
Lordship,
6-5.
11,
Okay, 11-5.
Lordship.
Because if I say I'll proceed, they'll not file.
Yes, my lord.
Then we'll now have to, in some case, pass some on.
Yes, yes.
Yes, Mr. Day.
Wherein also no affidavit has been filed.
Did you file?
No, not filed. Lord.
Well, yes, some time is required, my lord. The instruction is awaited still, not received by me, so my lord. But
But notices were issued on 10/1/25, Mr. Sharma.
yes.
On the prayer of Mr. U. Sharma, Standing Council, Secondary Education Department, registry to list this matter again on 11/5/2026. So Mr. Sharma undertakes that the affidavit on behalf of the Secondary Education Department would be invariably filed on or before 11/5/2020. No further opportunity for filing an affidavit would be granted to the respondents. Also,
Much of much.
Lordship, on previous occasion, some time was sought for to file an affidavit, Lordship. It is yet to be filed.
My lord, here in this series, my lord, I have received instruction in two matters. I think that will cover the, lord, just need some time to file affidavit, my lord. Because they have challenged one notification that will be covered by the any one
Same.
of the affidavit.
order. PMR as thus Standing Council, you Sharma bole kuch nahi order as Sharma as thus yeah, Education Director, Department of Higher Education. Fixing it on 11.
11.
Site ekkalage maidu. Passa.
In this case, they are supposed to file a affidavit.
Although I have received
Many
instruction,
occasions,
but
Lordship,
some
they
grace
took time.
is required, my lord, here.
On the last occasion, they submitted that instruction received only affidavit is to prepared and filed. Several occasions earlier, Lordship.
Yes, my lord, I have received the instruction, bunch of documents is there, my lord, but my lord, here it is stated that the district scrutiny committee has not recommended his candidature. So, my lord, regarding that, some clarification is required from the department, my lord. So, some time may be granted.
Same submission was on the last day.
What prevented you from taking that clarification on 19th? And where is the council who appeared on that day? She undertook that it will be filed.
He does probably in another court, my lord. So,
What is the instruction you have received?
yes, ma'am. Instruction
Your
is,
name has not been recommended by DLC.
Well, that is the problem. The matter was in earlier round of litigation remanded back to the director to decide the matter. Director did not decide. He thereafter matter he asked to Lordship DHC to recommend the name. DHC Lordship several occasions meeting was held and matter was again forwarded to the director to clarify the stand taken by the Lordship that That stand lordship has not been
What
clarified.
stand?
Stand that regarding lordship, there is a dispute between two persons. As the direction was given by the High Court to the director, but director is forwarded this matter to the DHC.
Yes, what is your case?
Number 8. We kind of
Forget your affidavit. What is your stand with respect to the issue raised by Mr.
senior is not present.
But the Learned Council for the parties at registry to list this matter on 12/5/20. The respondents are at liberty to file their affidavit. If no affidavit is filed in the matter on or before the next date of listing, this court would proceed to dispose of the matter basing on the materials already available.
My lord, may 15/5, my lord. And earlier matter, this my lord.
That's complicated. This is very simple.
Lordship, in this matter, I have received my instructions, my lord. I'll be filing my affidavit in opposition.
Can't take it in the face value.
My lord, I have got my affidavit.
Can't take it. Because in the last around 10 cases, for the last 3 dates, it is only said that instruction received, we file affidavit. Instruction received, we file affidavit. If you don't want to file, don't file.
No, in this matter, we'll file.
Yes, what is your case, Mr. Das?
My lord, the case herein is that, my lord, the matter, my lord, pertains to provincialization of service, my lord. Herein, the petitioner is the sole social science teacher of the school, my lord. Private respondent is, my lord, 6 is, my lord.
Okay, show me the particulars.
My lord, that is, lordship will find all page 31. That is the particular forwarded by the respondent number 6 himself. And on that basis, their services were provincialized. My lord, will find the Kuso Soikia, the respondent number 6, my lord, that on the extreme right side, Assamese his. And thereafter, petitioner Bhupen Guli, he is social science teacher. And my lord, Hindi.
Kishore Bik.
Kishore
English.
My lord, he is English. He is not a party, my lord. We do not have any grievance
And
against
where
him.
is the order of provincialization?
Provincialization order, my lord, only one order is there, my lord, but there, my lord, the list that has been published in the website.
Page 33.
My lord, yes, my lord, page 33, my lord. Kuso Soikia, my lord, his names appear at serial number 152. Kuso Soikia, thereafter Osud Das, he is, my lord, science and maths, and thereafter, my lord, Amitabh Sarkar. Amitabh Sarkar is Hindi, my lord, and Kuso Soikia is, my lord, Assamese.
So you are appearing for, Mr. You are appearing for?
I'm again for number 7.
7. 7 is Amitabh Sarkar. And who you are appearing for? Kuso Soikia. Forget Kuso Soikia.
Kuso Soikia.
Yes, Mr.
My lord, with all due respect, may I just, my lord, explain a little bit further, my lord? My lord, that the petitioner's name has not been recommended, my lord. Thereafter, he has prepared an appeal. And in the appeal, before the, my lord, Secretary of School Education, that order, lordship will find on page 50, my lord. And in, my lord, after perusal of the all record, my lord, placed by the concerned authorities, my lord, then order has been passed. That, my lord, my lord, in the table also, lordship will file that Kuso Soikia, that, my lord, resembles the staff pattern that has been submitted by the headmaster.
Then what happened after
My
that?
lord, the secretary says, my lord, on his decision, it is not in accordance with the, my lord, relevant provision of 2017 Act. Thereafter, my lord, thereby it has to be, my lord, reviewed. That order has been forwarded to the DSC. Now, my lord, the DSC, the district level committee, instead of, my lord, the reviewing the, my lord, that earlier recommendation, and, my lord, instead of considering the name of the petitioner, being the social science teacher, they have, my lord, take a resolution whereby, my lord, they have, my lord, they have made a resolution whereby they have, my lord, decided to, my lord, appoint that the headmaster is, my lord, required to be appointed as a, my lord, social study teacher, and Hindi as a language.
That is page 65.
My lord. That has been resolved by them, and virtually, my lord, with all due respect.
Who is this Bhavakanta Mili?
Bhavakanta Mili. Now, Bhavakanta is Mili is, that is, my lord, some, my lord will find.
Not your school.
Not my school, my lord. 63, my lord.
Where is the resolution, latest resolution of the?
63 lordship will find, and there, my lord, relevant portions.
Kuso Soikia, social studies.
Asud Das, that is Science and Maths. Amitabh Sarkar, Hindi. Kuswa Soikia, my lord. That, my lord, virtually by taking this resolution, may I read this, my lord, that a Pregab is there. They have prepared a
No, he was regularized as HM or assistant teacher. Or tutor.
He's my lord, as a tutor, my lord.
Tutor.
My lord.
Tutor. Achud Das?
Achud Das is also a tutor. He's my lord, Science and Maths.
Amitabh Sarkar also tutor.
My lord, Amitabh Sarkar is
So
also
this is
teacher.
the case.
This is the case, my
Yes. How Amitabh Sarkar came in?
Yeah.
Lordship, Amitabh Sarkar is a Hindi teacher, Lordship.
Hindi teacher.
Lordship.
Okay, done. And this signature at page 31 is of Kufa Soikia. Respondent number 6.
Yes.
Right?
Yes, that is prepared by Kuswa Soikia.
Do you dispute page 31?
Lordship. Yes, Lordship. Amitabh Sarkar.
So according to you, Kufa Soikia, Bhupen Kuli and Achud Das should be provincialized.
My lord Kuswa Soikia, my lord Bhupen Kuli, and my lord Kishore
Achud Das.
Not yes, my lord. Achud Das. Science and Maths. I am the social science teacher.
Do you have the earlier resolution of the DLC?
Yes, my lord. DLC. DLC minute.
Earlier minutes?
Earlier minutes prepared. That is not with me, my lord. That may be called for.
Yes, who is for the respondent number 6? You're disputing this page 31.
Sir, I'll take some time and file a response.
Why you take time? You have been taking time only. This matters cannot be. You're continuing with your provincialized appointment. We'll interfere with that today. You'll not be given any benefit. Admittedly, you're not entitled. Where is the dice code? Have you brought the dice code on record?
Dice code is not there, my lord.
You showed me the order of the
Secretary.
secretary. Where is that?
Yes, my lord. That lordship will find, my lord. On page 50, my lord.
Page?
Page 50. 50. On decision, my lord, the decision is on bottom. And my lord, on the table itself appears. Tables, the subject thought were there. It is, my lord, resembles with the staff pattern. And this table has been, my lord, on basis of the record submitted by the director himself. Herein also Kuswa Soikia Assamese, Amitabh Sarkar Hindi. Admittedly, lordship.
Yes. The commissioner and secretary, have you challenged this order, Mr.? Both of you, have you challenged this order? 14-10-23. Categorical finding that it's an appellate order. How can the subordinate authority now go against this? Heard the learned counsel for the petitioner at some length. The learned counsel for the this court on a perusal of the materials coming on record is of the view, is of the tentative view that the services of the respondent number
That's almost 6. 10, 7.
No, Kuhosoikia will otherwise come in.
My lord.
7 cannot come in. Amitabh Sarkar is 7.
Yes, my lord. The Kukosukia, my lord, he may come, but
He'll come.
my lord, but
7 will not come in.
Yes, my lord.
The respondent number services of the respondent number 7 could not have been so provincialized before provincializing the services of the petitioner. The Secretary to the Government of Assam, Department of School Education, via an order dated 14/10/2023, had already determined that it is that the respondent number 6 was teaching the subject of Assamese, while one Ochud Das was teaching the subject of maths and science. The respondent number 7 was found to be teaching the subject of Hindi. The petitioner herein was teaching the subject of social studies. Accordingly, applying the provisions of section 3 bracketed 11 of the Act of Pura Likhriba 2017, this court is of the tentative view that it is the services of Kusho Soikia, as Assamese against the Assamese subject, against as a language teacher, Ochud Das as maths and science teacher, and the petitioner herein as social studies teacher, who was required to be so provincialized. Also, accordingly, therefore, the provincialization of the respondent number 7 is been found to have been so effective in excess of the powers conferred by the provisions of the rule of 2017, Act of 2017. However, considering the prayer made by the Learned Council for the parties to grant them a final opportunity to bring on record their respective stands by way of filing an affidavit, the matter stands adjourned till 6/5/2026. The affidavits on behalf of the respondents be invariably filed on or before 5/5/2026, failing which this court would confirm the tentative opinion that has been drawn basing on the materials available on record as on date. Also, with the above, registered to list this matter again on 6/5/2026 for further hearing. You want to file, you file. Otherwise, I have drawn my tentative opinion. I'll confirm it. That's all.
Obliged.
Yes, Mr. Chetty.
Letter instruction was called for by this
You tell me.
honorable
what you
court's
want.
order, my lord. And
Yes.
My lord, instruction not received, my lord.
Why?
I have written,
Who is to give the instruction?
actually, it has to be come from the college authority. The
College service complete.
yes,
yes,
None is appearing.
whether any recommendation has been sent to the yes.
But this thing would have come to you now.
yes.
The recommendations made will be with you.
My lord has put a specific query whether that in person to that selection process, any recommendation was sent pending before the directorate or it has been sent by the
That
college
has been
authority.
sent.
But what is your instruction? That much you can't tell.
And my lord,
Whether the file is with you, whether the instructions, whether the proposal has come.
give me to be some short time, my lord.
Mr. S. Das, Learned Counsel for the petitioner, submits that he be given a last chance to complete his instructions with regard to the claim, to reply to the claims made by the petitioner in the present writ petition till 7/5/2026. No further adjournment shall be granted in the matter. Registry to list this matter again on 7/5/2026. The liberty is open to the respondent authorities to file an affidavit on or before 7/5/2026. In the event the such affidavit is not filed,
My lord,
this court, in addition to considering issuance of cost upon the respondent authorities for taking repeated time and not honoring the undertaking given for filing affidavits, would proceed to consider the repetition basing on the materials already available.
But affidavit is on record.
About 8 ko idea, 6 question, 13 ko idea.
But affidavit is on record, my lord. What had happened?
Affidavit is on
yes, my
record.
lord. Affidavit is on record. Then my lord has put a query. My lord, as if I go by the my lord affidavit, there's
Oh, yes, yes.
his
Yes, yes, Mr. Sorry, I missed up. Yes, yes. Mr. Chatri, argue.
Yes.
You can argue.
Yes.
I missed out. Yes.
No,
as per
only affidavit has been filed, but subsequently when lordships met the query after hearing the matter,
I
then
got it.
as per order, there is 6-3, my lord, 6-26.
I got it. I got
then
it.
then lordship
I was thinking something else, huh?
Lordship will find the recommendation, this resolution, my lord, at page 48, my lord. The resolution of the governing body regarding recommendation, my lord. And 50 is the minutes of the meeting. In terms of the honorable court's order, my lord, since the selection committee has been constituted and accordingly the recommendation has been made to the petitioner, my lord. And
Now, Mr.
it is pending before the
one thing.
lordship.
You are Gitali Das Bodle.
Lordship.
A resolution was adopted in your favor
Lordship.
by the governing body. You were number 2.
Yes.
You were number 2.
Yes.
The first one was given an appointment?
Yes, in Nagaon.
No. In your school?
No.
No appointment. But the recommendation was made in our favor.
Yes.
But that was not taken to its logical conclusion because this case was pending. Now, after this resolution was adopted and recommendation was made at page 46, what happened?
Nothing was. This is pending before the director.
Okay. What is the stand of the respondents?
My lord, there is no stand at all. My lord, only.
Yes, Mr. Forget the 15
My
marks.
lord, if my lord goes to the pleadings, my lord, that is not his case, my lord. That is not his case. That first one was not appointed or he has left the post. my lord.
It has been developed as such.
My
Now,
lord.
the second resolution in terms of the governing body resolution has been adopted, sent to you.
Yes, my lord.
What did you do with that?
My lord, that
Because under Rule 7, you have to act on that.
no, what had happened, my lord, before the selection process concluded, my lord, if my lord kindly see page 35. Before the recommendation sent, the petitioner approached before this honorable court. Then,
Okay.
my lord, kindly see.
Okay, got it.
Yes.
You want to complete your instructions, you complete it. We'll take it up on 28th. 28th of board assembly. 8/5. Okay.
My lord.
On 8/5, we are disposing of the matter
Yes,
on
my
that day. Hadilana counsel for the parties at some length. Mr. Esdas submits that he would complete his instructions with regard to the query raised by this court on wide order dated 6/3/2026 by the next date of listing. Registered to list this matter again on 8/3/2026. In the event the query raised by this court, and in the event the Mr. Das, although not like it. 8/5. 8/5.
That's it.
I think we are calling it a day. That concentration is gone. Any urgent matters?
No urgency, my lord.
Mr. Doctor, you were here for Ms. Doctor. Yes.
And the item number 65, my lord. I'm appearing for a lady teacher. He was denied for her appointment as a principal only on the ground that she pursuing MA without NOC. Lordship is a covered case. So any short date may
Item number 65,
service is
as prayed for, registered to list this matter again. A short date diya hai.
for
It's
admission.
covered by the judge. My
It's your lordship judgment also.
4/5. 4/5. Done.
In admission,
Admission, for admissions.
for admission.
A service, it is submitted,
service.
that the service is complete.
Respondent number 4 not.
Service upon respondent number 4 is complete. So accordingly, registry to list this matter again on 4/5/2026 for admissions. 66 likha. The registry to list this matter before any other bench without. 4/5.
Interim is to be.
Interim order passed earlier for today. Passed earlier to continue till the next date of.
Right. Yeah.
Any other urgent matters?
Item number 51, kindly give a date, Lordship.
Okay, she'll give the date. Date did you have? So, hey, May 3rd week mano pa didi ba? Budget खूप urgency असे होला. Any date you.
Declaration of result of a student, your lordship.
A law student.
Oh.
Law student, declaration of result, her result has been withheld, lordship.
Yes, why?
Milord, item 50.
Tomorrow she'll be practicing with you here only. So you got
Milord,
to face her.
It's regarding one second semester examination result. First appeared in 2015, and second attempt 2016, and third attempt not in 2017, 18, 19, 20, in 2021.
You permitted her?
Yes, Lordship.
Milord,
You permitted her?
Milord,
No, Mr. Ukon.
Milord,
I got it. That he has to complete it within that 3 chances.
Milord,
Now the first chance is 2019.
Milord,
No, 2019.
2015,
15.
Milord,
So she plugged.
Milord,
16.
Plugged.
She plugged.
Milord,
17, 18, 19, 20, she did not appear.
Milord,
21,
Milord,
she submitted the application to you.
Milord,
Yes, sir.
She did not appear by herself.
she was a student of Tezpur Law College. She appeared there and in virtual mode. So some, Milord,
No, the application was given to you. In
Milord.
that application, the registration number would be of 2015.
Milord,
How did you permit her? Idea happened. Yes.
paragraph 6, Milord, page 7.
You have filed an affidavit? No.
No, Milord. So, Milord,
No, what is this? Why are you before? The answer is the results have been withheld.
Lordship, page 26, the examination fees that was taken by the university in the year 2021.
it's on online mode.
Yes, Mr. Das, what is your stand?
Lordship, we have nothing to say, lordship. We have allowed, as per the direction, lordship, we have allowed, lordship, because the admit card was. Lordship, with lordship directs, lordship, because the direction has to be, issued. The prayer is to declare the result by the university.
No, she appeared from your
Yes, lordship, from page below.
and the application form was forwarded by you to Gauhati University.
Yes, sir.
Gauhati University permitted,
Permitted, lordship.
issued admit.
Should admit card, because without admit card, lordship.
Cannot
Cannot admit.
How?
It is printed admit card. Kindly have a look at page 19.
In our time also, we got printed admit card.
Printed
Nobody gave us it
without,
writing in
without
the
any
hand.
signature, but it should be countersigned by the principal of that concerned law college. Kindly have a look at page 19 or page 20 onwards. These are the
No,
Admit
you mean to say this is not correct?
no,
Oh.
Milord, Milord, no, Milord. Normally, admit cards, printed admit cards were supplied to the college concerned. And that is verified and countersigned by the college concerned.
So let's say it is signed
So-
there, Lordship. Principal sign is there.
Principal signs, but not the controller.
Okay.
So I think, Milord,
Mr. Elika, Third Day Learning Council for the parties. Mr. PJ Pukan, Learning Standing Council, Gauhati University submits that he be granted time till 30/4/2026 to yeah, 4/5/2026 to receive instructions as to whether the petitioner was permitted to appear in her semester exams for which semester?
Second semester.
Second semester examinations in the year 2021 by the Gauhati University authorities. First off, he submits that the admit card as brought on record. Oh, these are all old admit cards, Mr.
Milord,
Seventeen.
and regarding that admissibility aspect, Milord, 21 matter, it has been
receive instructions in the matter.
filed in 2025 after
Promise
4
that he
years.
be granted 2 weeks time, time till 4/5/2026 to complete his instructions in the matter. Also, the matter pertains to the withholding of the result of a LLB student. Also, by the Gauhati University authorities. Also, the reasons for withholding of such reasons for withholding of such results is, however, not disclosed. Also, accordingly, Mr. Pukan is granted time till 4/5/2026 to apprise, to complete his instructions in the matter. In the event the affidavit is not possible to be permissible to be filed before the next date of listing, Mr. Pukan shall place on record the written instructions received from the competent authority of the Gauhati University with regard to the claim made by the petitioner in the present writ petition. Also, in the event the registry to list this matter on 4/5/2026.
Can it be on 11/4, Milord?
No,
11/5, Milord.
no.
1 week, Milord, I'll be out of station that week, Milord. That is why.
11/5.
11.
No further adjournment shall be granted.
Milord.
In the event the instructions are not produced before this court, the register of the Gauhati University would be required to be present before this court along with the contemporaneous records to assist this court to dispose of the present writ petition, on a date to be fixed for the.
Milord, I will be allowed to argue on the aspect of
You
admissibility of
can
the.
do any argument, but
Since
come to the
For
point.
long 4 years, Milord, this writ petition has been.
First,
filed.
you tell me you permitted her or not.
Milord.
Then
that-
we will go to the next step.
That is the crucial aspect, Milord. I agree, Milord.
You have permitted her with open eyes. We'll not permit you to now deny her. We'll use our 226 months.
Milord.
Any other matter?
Most of them.
Item 57, Lordship. That's a similar matter fixed on 29, Lordship. This one.
As prayed for by Delana Council for the petitioner, registered to list this matter again on
29.
29/4/2026.
Right.
My lord, item 58, family pension matter, my lord, the date may be fixed, my
We'll give you.
lordship, obliged.
Has agreed to Pile Mari?
Lordship, item 59, Lordship.
Huh?
Item 59.
Uh.
Last occasion, this honorable court is directed to file their response, Lordship.
Oh, I have done enough today. They'll not file.
Suspense.
You take a date. On that day, if they don't file, we will see.
May I please, Lordship?
Regarding the salary, Lordship, they have received instruction, Lordship.
Yes, salary, not subsistence allowance. So we are government of Assam is giving subsistence allowance.
Paying.
Yes, he is receiving.
Suspension, again suspension.
Yes.
As
2007.
prayed for, item
59.
as prayed for by Delana Council for the parties registered to list this matter again on did the other. What is the allegation against you?
2017, Lordship. He was suspended 2017. He was-
17.
Yes, Lordship.
And you filed it when?
Lordship, 2026, he was, 25, he was acquitted, Lordship.
Acquitted.
Yes, Lord. January.
Okay. And thereafter you have filed.
Yes, Lordship.
Lekha, 24/20. 24. You complete your instructions.
Yes, yes.
So 17, no departmental proceedings.
No.
17, suspension.
Yes, Lord.
Criminal case, 6/2. Huh?
Yes.
It was under 6/2. Today also you are under suspension.
Suspension.
May I please, Lord?
Thursday. By slip. 8 to Thursday. By slip.
Lordship, in item number 76.
But if these facts are not borne on record, this matter will be taken up in 2030. No, 33 August, after I leave. Yes, madam.
In item number 76, Lordship, interim order is dear, Lordship. It will continue, Lordship.
Silo bade. Wherever there are interim orders, cycling equity. Interim order extend equity. Mr. Patwari, anything? T?
The K culture.
Mr. K. Kolitas, private respondent, how are you?
When the petitioner was suspended, he was working in Bazali College. Not was taken up. Now my lord is there for into my Dr. Devi. I'm representing the university.
Oh, that matter.
Yes, Lordship.
But we have, I think, disclosed yesterday. Somehow I missed that file.
He was directed us to obtain subsidized allowance or not. He's getting subsidized.
From whom?
From government.
From the university.
No, no.
So you have recognized him as your employee.
My lord. Now, on the last occasion, this honorable further directed to the honorable wanted to know whether any disciplinary proceeding is pending or not. That instruction was
Yes, instruction is there. That is that discipline we have Lordship.
Nee, disciplinary proceeding.
No, Lordship, that file we have misplaced, but Lordship, in the suspension order itself, there was a direction to the principal to constitute a committee.
What is this case? What is the name of the party? Item number?
59. Baneshwar Das.
Haneshwar Das. Okay.
Lordship.
Not Guru Prasad Khatuniya. Sorry.
Baneshwar Das.
Sorry. ठीक है सर, ठीक है सर. Yes, any departmental proceeding instituted against him?
Yes.
So, well, that instruction.
No, that they have sent it to you.
Yes, that's right.
Any department?
On 17 they have sent it.
22-4, they have sent it.
70.
On the back side, Lordship.
Okay, 17-4. What is your stand on that?
I have to obtain it.
Seem to be a very powerful man.
Yes, sir. And the other case Lordship mentioned, but it back to ZU and ZU's disciplinary proceeding.
He's a grade 4 employee, Lordship. Grade 4 employee.
Very powerful.
Not a. Not a good.
You complete your instructions. Friday, no? 27 quid, yeah? For further hearing.
27th.
For further hearing.
Yes.
You complete your instructions.
Yes, I'll do that.